There's a market 0 to 14. But now aware that Georgia has been maybe more today because the student maintained 100 markers and players. But I'm only playing after a Wednesday possibly.
It will come up. It will come
But
up.
the problem is that now in furtherance to the reversal that was done in the appeal, now the respondents have went on to get hold of the entire property. So that's why I'm saying unless until it is admitted, I'm aware that the stay would not be granted.
Please just hold on for some time. What he has to take recourse to law only to get
yes,
hold of the
he's
property.
taking recourse only. He's not doing it deliberately or so. He's taking
Let
recourse.
him take nothing.
It's a case
Payment
of
is
reversal.
not going to fall.
It's a case of
You
reversal.
see, in this court, it is not so easy to
Yes,
get a substantial question of law, even in cases of reversal.
Yes.
So you just can't say that merely because it's
Absolutely,
a case of
absolutely.
no, it is not possible. Please don't. It is simply not possible. It is simply not possible that though so many cases, I think around 400 cases are on board, I will not have time to take up these matters.
Some date, any date.
Every case has a date here. Every case has a date. It will come to the corresponding
This
week.
is also coming as a date fix only. It was not being taken up because of the heavy board. I'm only doing because these are taking orders because of a substitution that was done because
Orders are taken up at 4 o'clock.
वो stay तो कभी होगा जब admission पे जाएगा उसके बाद होगा
कोई बात नहीं आप पहले orders देख ऐसे नहीं करते.
From date is for finance office case item 1, second appeal 4 of 2004.
This is your submissions?
No. All the same.
You have also given?
No.
Not required. Okay. Slowly और आराम से. CAB नहीं करना है आपको. कोर्ट में डिक्टेशन देंगे. सीधे एकदम इत्मीनान से.
But first, I would like to respond my IA for eliminate additional question of law. For that, let us first have the plate so that the case is clear. Then I can argue that this question
Do you
also.
want to respond to the IA or I should decide it?
Yes, I will argue.
What is it, IA?
Yes. But can we take the blame first? But the case.
No, where is the, what is the additional substantial?
Yes.
IA number? This one IA 13868 of 25 that has been done.
15654.
15654. What is the proposed date?
Yes.
How many more questions do you want?
But
Yes?
4 questions I have proposed, and all these questions, Lord, in my humble submission, is very relevant.
Why didn't you argue when the case was being admitted? Who stopped you from advancing arguments on these substantial question of law?
Lord is aware, Lord, once you are decided, Lord, and appeal after having 2 courts against you is admitted and a liberty is granted for Lord, even if it is admitted on one question of law.
This substantial, proposed substantial question is sir. These were never raised before neither the trial court nor the appellate court. They are raised first time before
We'll see
this
that.
honorable court. Yes, sir.
So much, sir.
You just read.
Yes.
आपका एक सेंटेंस जो 2 वाला है वो 1.5 पन्ना का है. 1.5 पन्ना का सब्सटेंशियल क्वेश्चन ऑफ लॉ, 1 सब्सटेंशियल क्वेश्चन ऑफ लॉ 2 पन्ना का.
Lord,
मतलब how do you by the time I reach the end of the sentence I'll forget how the sentence began.
इसीलिए हम उसको उसी में एक्सप्लेन भी किए कि क्या सम एंड सब्सटेंस में क्या क्वेश्चन फॉर्मुलेट है.
बताइए. पहला रोमन 1 पढ़िए.
Yes. Whether the gift deed executed in the year 1947 would have been held a document which was never acted upon, and no title would have been transferred in favor of the plaintiff on basis of the gift deed, particularly in view of the fact that Exhibit 5 filed by the plaintiff themselves shows that the name of the recorded year Gopal Sahu in the year 1960-61, and therefore the story of the gift deed of the year 1947 stands reshaded in view of Exhibit 5. But because the plaintiffs here are claiming on basis of a gift deed of the year 1947, through Gopal Sahu. It is their case in the plate that by virtue of this gift deed, we were given the property, the plaintiffs, and the ex-landlord granted them rent receipt, and the ex-landlord also filed a return in their favor, and Exhibit 5, their own document shows that their name does not find mention in the return Exhibit 5. It is Gopal Sahu, the recorded agent. So from this notes, their own statement in the claim and their own exhibit itself demolishes their case of guilt.
Roman 2.
Yes, ma'am. Whether the findings with respect to title of the plaintiff, which have been decided by the first appellate court, as issue number 2, para 21, is based upon irrelevant consideration and in ignorance of relevant exhibit, as the first appellate court, by deciding the title of the plaintiff, have taken into consideration exhibit 7, certified copy of degree of title suit, in which the defendant are not a party and the said suit belongs to a different plot, which is not the suit plot in question, so far as exhibit 2 has been considered, which is entry in register 2, it is well settled that record of right, mutation entry does not create or extinguish the right title interest in, and further relying upon the weakness of the defendant case, title in favor of plaintiff have been declared. In view of the above, whether the judgment of the learned first appellate court by deciding the title of plaintiff is vitiated for consideration of irrelevant exhibit and non-consideration of relevant exhibit, that is exhibit 5, which shows that the due period of the year 1947 has never been acted upon. The return which was filed was showing the name of recorded alias Gopal Sahu even after 13 years of the guilt deed, from which it is evident that guilt deed was never acted upon, coupled with the fact that the plaintiff never came in possession of the suit property, rather possession was all throughout with the defendants. But in
It's a one and the same. Roman 1, Roman 2.
Roman 1 and Roman 2 notes are not in one in the same, because notes in deciding the about the gift deed, declaration of title, but the appellate court have taken
All these exhibits, issue number 2 was in connection with gift deed.
gift deed. It was in connection with the gift deed, and only 2 exhibits have been considered, that is exhibit 7 and exhibit 2. Exhibit 7 is a title suit compromise judgment between their family members, which is not with respect to the suit property, and neither the defendant was a party in that title suit. We are taking into consideration an exhibit which does not concern the suit plot itself. The court declares the title of the plaintiff. I will show from exhibit 7 that is with respect to a different plot.
So according to you,
Yes,
if we frame an additional substantial question of law as to whether the findings in connection with issue number 2 is vitiated on account of misconstruction of exhibit 2, 5 and 7, that will be sufficient.
Yes, that is sufficient. So far as deciding note, this issue number 1 and 2 is concerned.
Issue number 2. And what about Roman 3?
Yes. And whether the judgment of the court below is vitiated for not deciding the issue with respect to the relationship of plaintiff with reported alias Gopal Sahu, more particularly when the defendant have denied the relationship and no document was exhibited on behalf of plaintiff to prove the relationship, and even evidence of PW shows that plaintiff and recorded alias were of different caste. In view of such, whether without deciding the relationship between plaintiff and recorded alias, the suit of the plaintiff would have been beaten.
So this issue was also not framed.
Sorry?
This issue was
No,
also not
it was
framed.
not framed.
So you want a wholesale remand.
No, I don't want a remand.
If there is an issue
Yes,
which has not been framed, so if that issue is to be decided, so what are you looking for?
but therefore, once there was a
Therefore,
demand,
this suit of 88 to be remanded.
no,
What is the
saying-
consequence of this kind of a substantial question of law?
But because in the plaint they have stated that they are bhagnas of the recorded barrier. We have denied it categorically. But
You were the
without,
appellant before the first appellate court?
yes, I was the appellant.
Did you raise this issue?
But that the memo appeal.
Oh, we do not know.
Yes, I read the memo of appeal, did not raise.
You never raised this
Let
issue.
me take this note. The Lordship will not frame that question of law so far as relationship is concerned. Let us see point number 4. Whether the finding given by the first appellate court with respect to requirement of notice under section 106 of TP Act is concerned is bad in terms of the judgment reported in AIR 1957 Patna page 36, where a similar issue of underlayer as that in the present case was under consideration and the court have dismissed the suit on the ground of notice under section 106 TP Act as in the present case. It is admitted fact that no notice under section 106 TP Act was ever issued, and there is no pleading in the plaint with respect to the notice under section 106 TP Act and no exhibit have been marked on behalf of the plaintiff to show that notice was issued under section 106 and therefore the suit of the plaintiff was not maintained. This was the issue taken up by the first appellate court and decided by the first appellate court, relying upon a judgment which deals with relationship of landlord and tenant. I will cite that judgment to satisfy your lordship because that judgment in the facts and circumstances of the case does not apply at all. And in one small paragraph note, the appellate court quotes that judgment and says because there is a dispute with respect to the ownership, therefore.
Is there any finding of the learned first appellate court that the suit was vitiated for want of notice under section?
No, the appellate court says that no notice is required and therefore notice under section 106 is not required. This is the finding of the appellate court, relying upon the judgment.
Did you take a plea before the learned trial court that no notice under section 106 TP
But
Act was
appellate court was there.
Did you take a stand?
Yes.
Okay. The plaintiff did not say
Yes.
that notice under section 106 was not issued.
Yes.
Did you take a stand that in absence of the notice under section 106,
Yes.
the suit was not maintained?
But I have taken a stand so far as my written statement is concerned. It is not in the words I have stated that the present suit is not maintainable under law.
So that is absolutely vague.
So not even if it is vague, not the appellate court takes into consideration this and the appellate court decides this issue against me, relying upon a judgment which does not deal with the case at hand. The appellate court considers a case where there is a dispute of relationship and of landlord and tenant. The tenant atones the landlord. He pays rent to the landlord. And in that situation, the appellate court have taken into consideration that judgment and have said the notice is not required because this judgment says so. He just picks one line of the appellate from the judgment of Patna and what says on basis of this judgment, it
So
says.
at best, the substantial question of law would be that the parties did not join issue. So far
There was
as
issue because
the parties did not join issue in the plaint and the written statement of this. The parties did not join issue in the plaint and the written statement for in connection with want of notice under section 106
But-
of the TP Act.
But in place of written statement, it is not there, but the appellate court it was argued, it was taken.
Therefore, the finding of the appellate court entering into this issue is perverse.
But
Therefore, it is perverse
But
because the parties never joined issue
But
in connection with
it is for
issuance
the
of notice.
plaintiff, Lord, it is for the plaintiff in law to stand on his own legs. It can't be that since I have not taken a plea under law, which is a legal plea, not a factual plea, that was taken up by the appellate court. I can't argue this that the finding of the appellate court is bad. Because in written statement I have not taken a specific plea that 106 notice was not issued. Because the plaintiff, it does not say so. It is for the plaintiff to come up and say that I have given a notice under section 106 TP Act, I fulfill the requirement of law.
And in absence of notice under section 106 TP Act, the suit is not maintained.
It is not maintained. This is what the judgment says, which I have quoted.
1957 Patna.
Yes,
37.
yes,
Where is it?
yes.
Is it an agricultural lease?
Yes. Because since 1912, my possession is recorded as a Dar Raiya. It is under Raiyat of the recorded tenant Gopal. Sir. Therefore, I said, Lord, can I place the plain first so that the case is clear? On that background, we also test which judgment is applicable in this case.
What was the ground for eviction?
Sorry?
What was the
The
ground?
ground for eviction, the plaintiff said that Gopal Sahu is the recorded Raiya, and it is admitted case that we as a defendant were the Raiyas of Gopal Sahu in possession before cadastral survey, that is 1912. So it is admitted by both the parties that we were in possession before 1912. They say that Gopal Sahu, ये इनके भाते हैं plaintiff, he used to reside with him. Gopal Sahu being pleased with him, granted a gift deed in the year 1947. Then they say on the same breath that after 1947 when Gopal Sahu died, the Zamindar lords accepted us.
I just want to know
Yes.
what is the ground seeking eviction?
But the ground seeking eviction is, as per them, that they want possession back because we are not giving them the rent, and therefore they are seeking eviction. This is paragraph.
Default payment of rent.
They say that the defendants are the Raiya and tenant at will. They are not paying the Raiki advertised rent for the last 2 years since January 1986, for which the plaintiff does not want to continue the defendant to remain in possession of the suit Schedule A as the Raiya, and therefore they are seeking eviction. And they say that since January 1986.
पढ़िए 106.
Yes.
As it stood pre-amendment. 2003 में amendment हुआ ना? सूट तो आपका 88 का है ना?
88 का.
हाँ, basically pre-amendment.
हम लोग इसमें जजमेंट एकदम पुराना है 57.
अब
It was
ये आप ये पढ़िए 106.
अच्छा उसका नीचे में है duration of certain lease in absence of written or local usage. In absence of a contract or local law or usage to the contrary, a lease of immovable property for an agriculture or manufacturing purpose shall be deemed to be a lease from year to year, terminable on part of either lessor or lessee by 6 months notice expiring with the end of year of a tenancy, and the lease of any immovable property for any other purpose shall be deemed to be a lease for month to month, terminable on the part of either lessor or lessee by 15 days notice expiring with the end of the month of tenancy. Every notice under this section must be in writing, signed by or on behalf of person giving it, and either by sent by post to the party who is intended to be bound by it, or be tendered or delivered personally to such party. Or
This
any,
notice is irrespective of any default in payment.
yes,
So notice under section 106, how is it required?
because of terminating the lease, because it says
No, even for, there are two ways of, for evicting a person under, by issuance of notice under section 106,
yes, bro.
the tenant need not be in default.
Yes, did
You
not
can,
be
you can simply give him a notice, you
Ah.
evict and he evicts.
Yes,
right?
Yes.
This is the tenor of 106.
Yes, yes.
But in case of default, where is the requirement of
Therefore, I
giving a
say,
notice under
therefore I
section
say
106?
there has to be an adjudication to the fact
Not,
that whether
you
I am
see,
a tenant.
none of the parties have joint issues regarding issuance of notice under section 106. The suit was filed alleging default in payment of rent.
But this is not an eviction suit on the ground of BBC Act.
No, it is not a
It is
BBC
not
Act.
BBC Act.
Even in case
Therefore,
of,
your lordship will not consider this of a default in payment of rent.
you see, that was the suit that the Rayat has not been making payment of rent and therefore he should be evicted. You
No.
just read the prayer,
No,
right?
I have not read the no, that is one of the paragraphs. Your lordship has to see the plaint in its entirety. This is not the Lord. If your lordship is
No.
if your lordship is
The appellate court has held
yes, Lord.
that notice under section 106 was not required.
Yes.
But at the same time, the parties did not join issue on that, and therefore there is no need for additional substantiation.
But therefore I say, Lord, once the court says that there was no requirement of 106 notice, I say this that there was requirement because I am
You did
another.
not take such a plea.
No,
You did not
no.
take such a plea that no, in absence of any notice, the suit was not maintainable, or that will simply you say it was not maintainable.
It was
It
not
is as
maintainable
written.
under law. I say
What do you
this.
mean under law? No. This additional
So your lordship will
substantiation
see the
is
Lord
not.
judgment of the
We'll see
appellate
that,
court.
we'll see that.
No, your lordship will see the appellate court judgment on what judgment they feel right and dismisses that issue against me.
Parties never joined issues on that. So therefore, it is absolutely irrelevant for the learned appellate court to enter into the appellate court should not have even entered into such an issue.
But I say this that it was the duty of the plaintiff.
The appellate court should not have even entered into such an issue.
Lord, it
When the
was-
plaintiff is filing the suit alleging default in payment
it
of
is
rent.
not your lordship has kindly see the.
You read it?
No,
You read it?
your lordship will see the player there. Your lordship will see the player. Well, if this has to allege a default, then Lord, they have to Lord, give because default your lordship is aware of BBC Act. It is the only law.
No.
But then,
What do you mean? If a person is not paying rent to the state, if a person is not paying rent to the state can initiate a proceeding for eviction.
for state.
For
Because state
anybody.
is the superior landlord.
Whatever it
Yes,
is,
Lord.
we will see the plaint as it is.
Yes, as it
So
is.
therefore, you cannot say that a default notice can be given only under the BBC Act.
No. But I say, even without issuing notice under BBC Act, if there is too much default, eviction suit is maintainable.
Yes, it
There
is
is no
maintainable.
dispute on this, on issuing notice for default. But here it is not a case of under BBC Act. Here it is not a case. It is 106. It is a lease. Agricultural lease. It is a lease, and that lease was 1912. I was a Darayat in possession. But the kindly see the plaint itself.
I will see your judgment first and then.
Yes, very good. May I please this one? 1957? Yes. This is an appeal by the plaintiff on the decree dated 5/3/49 of so and so additional subject affirming the decree dated itna by so and so. The suit was brought by the plaintiff as Rayat for eviction of defendant from 1.66 acres of land comprised in Khata number 112 in village Jharkhand substantially on the ground that the defendant were under Rayat and have refused to vacate the land and give the plaintiff khas possession even on service of notice to quit. The defendant registered the suit on the ground that they had acquired permanent occupancy right in the suit land by adverse possession. Their additional plea was the suit was incompetent as they had not been given notice to quit the land. The learned Munsif held that the defendant has not acquired any occupancy right in the suit land. He further held that the question of acquisition of tenancy right in the land by adverse possession did not arise as the defendant in capacity of underlayer could not prescribe against the landlord. He further found that there was no demand for possession and after so holding he dismissed the suit. On appeal, the learned subordinate judge held that the defendant have acquired permanent tenancy right in the suit land by adverse possession and set aside the finding of the learned munsif to the extent. He, however, held in agreement with the learned munsif that there was no demand for possession of the land by the plaintiff and therefore the suit was not maintainable. He accordingly affirmed the decree passed by the learned munsif and dismissed the appeal. Before I deal with the question raised in this appeal, I would like to dispose of one short point taken by the respondent. One of the contention of the respondent was that by the reason not, we can skip this because this is bar of suit. Paragraph 4, you can skip, Lord. If the lordship say.
Yes. Continue?
Yes. But should I read this also?
No, not required.
Because Lord, next state, Lord, secondly, this was not a pure suit of by a landlord for ejectment of tenant. In the suit, the plaintiff claimed declaration of title and possession, and the suit of this nature does not fall under the CNT Act. And therefore, Lord, the court held that suit is not barred. Para 5 onwards. On behalf of appellant, Mr. So and so argued that the respondent did not possess the land for a statutory period of 12 years in order to acquire
This is adverse possession.
adverse possession. Because Lord, other question is also with regard to adverse.
Then further.
Yes, Lord.
On notice under section 106.
But let us see Lord, next page. Thus they have cultivated the land as Agrat Kaita. Because here exactly Lord, similar to my case. Thus they have cultivated the land as Al-Qataida continuously for nearly 15 years before the institution of the suit in 1946 on the strength of continuous possession for more than.
This is not the point. You are referring to section 106
Yes,
notice.
I am
Show me the
referring to
finding. Show me the finding in
Yes.
connection with 106.
Wait. But because other question also involves adverse possession issue, but so far as your lordship query with regard to 106 is concerned, for paragraph 8, paragraph 8. Apart from this, there is one vital defect. Both courts have concurrently held that the tenancy of the defendant was not determined by the plaintiff by a notice, nor was there any demand for possession. On this finding, they had held further that the suit was not maintainable. In this connection, Mr. So-and-so has been that no notice was necessary since the plaintiffs were mere tenants at will. As held above, they were not tenants at will but under rayat of the disputed land. In the unreported case of so and so, in which the defendants were under rayat, so and so proceeding seemingly held that notice was necessary. In another unreported case, so and so held that even in case of tenancy at will, a demand of possession or intimation to the tenant determining his tenancy was a prerequisite to the institution of the suit for ejectment. Assuming that the defendants were mere tenant at will, a notice to quit will be necessary to afford the plaintiff a cause of action for the suit. The statement of law on the question of notice will be found at page 120 of Ansari so a tenancy at will is determinable by either party on his express or impliedly intimating to the other his wish that the tenancy should be at an end. But until such intimation, the tenant is lawfully in possession, and accordingly the landlord cannot recover the premises in an action for recovery of the land without previous demand of possession or other determination of the tenancy. In either case, therefore, a notice to quit or demand of possession was necessary for institution of the suit. Thus, on the findings of the court below, that there was no notice determining the tenancy nor any demand of possession, there was therefore no cause of action for the institution of the present suit of ejectment of the defendant. On this ground alone, the suit must be dismissed. Here, not exactly what I am a yet we are in possession. They say that we.
It is not a simple case for seeking ejectment. It's a case where the plaintiff is alleging that there was a default in payment of rent. Therefore, you see, if a person is a owner of a property and there is a rayat or daj rayat or whatever, if you want simple eviction, irrespective of any fault on the part of the daj rayat, Section 106 notice is mandatory.
Now you have to kindly see the plate, the relief. What is the relief in the plate?
We will not see only the relief.
Let me just place
We
the
will
relief
see something
first
more
and
also.
then- Yes.
You just read it from the judgments. Judgment में होगा ना what is the relief in the plaint and what ये उसमें गलत लिखा हुआ.
But हम तो प्लेन ही दिखा रहे हैं कि क्या relief claim कर रहे हैं ये. Because they are also claiming title.
That's right. They are
Yes.
claiming title.
But he has sued for eviction.
If they are claiming title
Yes.
and seeking eviction,
Yes.
then there is no question of 106 notice.
There is.
106 notice question will arise only if there is a relationship admitted by the parties. If a person says that he is nobody,
But one
and if a person is seeking declaration of title,
Yes.
saying that he is nobody, right? And I should get possession of the property, why a notice under section 106 is to be issued?
Let me take it like this. My case is all throughout that I am a Dalayat in possession.
Whatever be your case, we have to see the case of the plaintiff.
Yes. That's what I say. The Lordship may kindly see the plaintiff. Let us see not the relief. That after adjudication a decree may be passed in favor of plaintiff, declaring the plaintiff has subsisting title over the suit land, schedule A to the plaintiff as earlier. A decree may be passed in favor of the plaintiff, directing the defendant to hand over vacant possession of the suit land, schedule B, to the plaintiff by certain date, failing which the plaintiff must be pushed in khas possession of the suit land through court by evicting the defendant, a decree of cost and other means. This is the nature of the relief claim in the plaintiff. And the appellate court will relies upon a judgment which is between landlord and tenant and says 106 notice is not required.
Which judgment the court has
Yes,
relied upon?
I'll cite that also. Let us see the appellate court finding first and then I will cite the judgment which has been relied by the appellate court. But paragraph 20 of the appellate court. You also see paragraph 20 of the appellate court. It should be your internal page 23 of the document. Paragraph 20, what am I doing?
Paragraph 20.
Yes. 106 notice note.
Yes.
Document kindly flip the page note. From the plaintiff, it appears that the suit land was given on advertising to a defendant by the plaintiff received now in 1979 and 1986. The defendant did not pay advertising to the plaintiff, and in the year 1988, when the plaintiff asked the defendant to hand over the suit land and the defendant refused to, and further they challenged the title of the plaintiff over the suit. From the written statement of the defendant, it appears that they have out and out denied the title of the plaintiff over the suit land, and to the contrary, they have claimed their own title over the suit land. From page 0 of judgment of Honorable Patna High Court, reported in BLDS 1959-376, as per the provisions of 106 Act, it appears to me that the suit is by the landlord for ejectment of a tenant. Notice to quit is not at all necessary to the tenant, has denied the landlord's title before the suit. Since the deceased plaintiff is the landlord, filed in the suit in court below is the defendant as tenant. As per the plaintiff, defendant challenged the title of the plaintiff over the suit land. In view of opposite decision, the notice under section 106 TP Act was not required to be served upon defendant as a plaintiff. Do not court consider takes that I am the tenant. It is an admitted case that I am a tenant, whereas it is not an admitted case, and the
No,
judgment.
court is not saying. Court is saying that he is disputing the
Yes.
title. He is claiming that to be the owner of the land. So, if both the parties are claiming title over the property, where is the question of issuance of notice under section
But
106?
they are claiming title on
Whatever be the basis,
No.
they are claiming independent title.
No. Therefore, I say not. I am a Daraya under Gopal Sahu. They are claiming title by virtue of a gift deed of the year 1947 through Gopal Sahu. So therefore,
That is not the case of the plaintiff.
this is the case of the plaintiff. This is exactly the case of the plaintiff.
इतना
They are-
सुनाने की जरूरत
But
नहीं
they
है.
are claiming to Gopal Sahu.
इतना जोर से बोलने की भी जरूरत नहीं है. We will see, we will read and find out what is the
Yes,
case
yes.
of the plaintiff. We just have a look at this.
Let us see the plaintiff notes to see.
No, ये जो judgment में लिखा है उसको ना देखें, गलत लिखा है.
किसमें?
Page number 4.
Note, हमको तो वही
You
तो
read page number 4, please,
page number 4.
of the appellate court judgment. Page number 4. The plaintiff's cases.
The plaintiff further case of the plaintiff
Yes.
reveals that the said recorded the died sometime in the after financial survey, but his son Ruplal alias Rupa Mahato neither came in possession nor continued in possession of the suit land as the Rayyat, and after his Rupal's death, his son defendant number 1 Laji Mahato, now deceased, and his son defendant number 255 in Jaina, date month of 1979. AD approached the plaintiff to settle the suit land in their favor as the Rayyat on advertisement. Approached the plaintiff to settle the land in favor as the Rayyat as advertised, and on being persuaded by the plaintiff, deceased now orally settled the suit land in favor of defendant as the Rayyat in date 1979 and put them in possession. Lord, may kindly pause here for a moment. Lord, date 1979.
पढ़िए ना.
और हम एक चीज दिखाना चाह रहे हैं, क्यों लॉर्डशिप दिखा रहे हैं 1979 डेट, तो लॉर्डशिप अवेयर वर्ड -57 होगा
AD.
AD
AD लिखा हुआ है.
हाँ डेट वही बोल रहा हूँ
Date 1979 AD. AD means what? English calendar year.
Lord 1979, if they say it is, therefore I say not date 1979 लिखा है.
AD भी लिखा है साथ में.
हाँ,
So AD means what?
but it is all throughout their case. Your lordship will see the plaint itself. क्योंकि जजमेंट से लॉर्ड कुछ पार्ट निकाल करके अगर हम देखें प्लेंट देखा जाए लॉर्ड क्या केस है इनका, इनका ऑल थ्रू आउट केस है कि कब हम पोजीशन से हटाए इनको, कब हम ये हमको इनका क्या केस हो इस पैराग्राफ 4 से आ रहा है कि हमको ये एडवर्टाइज में जमीन दी ओरली हमको दी 1979. तो लॉर्ड इनको अगर हम ये हमको जमीन देंगे देन ही हैज टू स्टेट कि when I was dispossessed and then he gave me possession back and he settled me on advertising. This has to be their case. 90 is their case.
देखिए. और क्या बोलना बताइए.
But then your lordship is not satisfied with lordship and reject the application.
Certainly.
Yes.
आपको क्या बोलना.
Yes, Lordship, so far the last proposed substantial question is concerned, section 106. The section 106 Lordship applied only for the lease of contract. This is not a matter of lease of contract, Lordship. A suit for declaration of title and recovery of possession, no notice is required under section 106 of the transfer of property. Lordship, again is the judgment of the Honorable Madras High Court, Lordship.
आप हमको ये बताइए
जी.
in page number 4 of the appellate court judgment, you say that you appointed him as the lawyer.
जी.
The जो भी नया आए 1979 AD.
हम्म.
And then you allowed him to occupy the property,
Cultivate
the land, but he neither paid advertise, right, nor rent for 2 years since January 1986.
Yes.
I want to know that in a simple case of suit for eviction,
This is not the suit of eviction.
सवाल ही suit है ना.
Answer.
In a simple case of suit for eviction, without any fault of the rayat or the rayat, right? A person can simply give eviction notice under section 106 and he is bound to evict. Correct? उसके लिए कोई condition, default या alteration या कोई इस चीज की जरूरत नहीं है. आपने land दिया है agricultural land, you give him notice under section 106 and he is bound to evict as per 106. In case where you are alleging default in payment of rent or default in payment in giving the rayati rights, the rayati advertise जिसको बोलते हैं, then under such circumstances is a notice under section 106 necessary?
Not necessary. Dr. Mekanisi is relying the judgment of the Honorable Madras High Court also. Sir, इसको दीजिए सर. And mark in a suit for declaration of title and recovery of possession, the main relief of the plaintiff is for declaration of title and recovery of possession. Notice under section 106 of the Transfer of Property Act is not required. The burden of the proof lies on the defendant to establish prescriptive title, failing with the plaintiff's title prevails lordship.
In this particular case, the defendant had claimed independent title. They had also claimed title or they had not claimed title?
In my case, lordship,
In this case.
they have not claimed title. No counterclaim was filed. And admitted that it is the Dharayat lordship. And
No, they registered the suit on what ground? On ground of adverse possession?
The plaintiff lordship.
No, the defendant.
There
They are the defendant.
is no plea of adverse possession lordship.
Okay, right. There is no plea of it.
There is no.
We'll see that. But the substantial question of law is dealing with adverse possession.
Look, it is not barred by the law of adverse possession. It is not barred by law of adverse
Okay,
because
we see that.
there is no plea lordship.
You see, on what ground the defendants registered your suit? On what ground did they
On the
register?
ground that I am the possessor of the land.
No, on the ground of only possession or they claim title also?
No, lordship mechanism is the lordship claim. Sorry, WS lordship. It will be clear lordship. Mechanism WS lordship.
But paragraph 14 not claim title.
हमको फिर बोलिए हमको लordship हमसे पूछिए.
देखिए हम आएंगे उसमें बाद में. पहले आप हमको इंक्लूड जजमेंट से दिखाइए. पैरा नंबर 5, the case of the defendant as per written statement. Header of appellate. Para 5, page 6.
The case of the defendant as per the written statement, the suit is not maintainable in law and plaintiff has no cause of action and suit is barred by law of limitation and adverse possession. And suffers from the problem of misjoinder and non-joinder of the party. The defendants in written statement admitted the contention in plain that land of Khata number so and so, area 1.84 acres of the Khata number so and so, were in the name of Gopal Sahu. But the said Gopal Sahu recorded tenant died, issueless, leaving behind no heir in the year 1948. The defendants further ever in written statement before the survey and settlement operation on Thirit Mahato was in possession of the suit land as a rayat in possession, but the subsequently it is said that recorded tenant recognized him Thirit Mahato as the rayat, and the rayat of these defendants are heritable by custom, and the plaintiff being no legal heir of the recorded tenant cannot challenge that the defendants have no heritable right over the property. The defendant later ever in the written statement that tenant of Khata number 17, that is Gopal Sahu, had allowed legal heirs of the Dilip Mahato, that is son and grandson of the Dilip Mahato, to enjoy the property and remain in possession of the same. Consequently, the plaintiff has no right, title, interest, or possession over the same. And Gopal Sahu recorded that until his death never remained over khas possession, but it is defendant who have possession in the lifetime of the Gopal Sahu and after his death also. It is further added in the written statement that the Gopal Sahu was recorded the year of Khata number 70, but till the death of Dilip Mahato in the year 1944, Gopal Sahu was never disturbed the peaceful position of the aforesaid Dilip Mahato and Kami as Bataidar of Khata number 1. It is later in the written statement that after the death of the Dilip Mahato, the recorded event allowed the heirs of the Dilip Mahato to remain in position as at Bataidar. The written statement further speaks that above said Dilip Mahato died leaving behind him on so and so date his son Rupalal Mahato, who succeeded the property of Khata number 1, and he used to give at Batai to Gopal Sahu. So recorded tenant of Khata number 70 allowed and permitted Rupalal Mahato, his son Lalji and grandson of defendant number 224. The defendant applied further ever in written statement that since the date of survey and settlement operation of this district in the year 1992 to up to date, the defendants are possession. So under the land, under the year acquired occupancy right in the suit land. Now the defendants have valid title by the realty settlement. They will no further remain as the real. The defendants later in written statement say that in the year 1944, Gopal Sahu surrendered voluntarily the suit land, so he had no right to transfer or execute any deed of gift in favor of one and so-called deed of gift dated 3/11/1947 general and white policy by Chotu Saab never came in possession of the land in possession, always remained with the defendants, and the gift deed is created document to disturb the rightful possession of the defendants, and Chotu Saab neither had or nor has any right to bear rent if there is any that has been obtained in collusion with the contract. The defendant as per the
So basically, the defendant is claiming that the suit land was in possession of Dhrit Sahu, who was the Rayyat.
who was the Dar.
Dhrit Sahu was also the Rayyat
Dar
of Gopal Sahu.
Yes.
Dhrit Sahu was the Rayyat of Gopal Sahu.
Gopal Sahu. Law is well settled that Dar is neither.
So he denied his status as the Rayyat.
Who is?
The defendant, they denied their status as the Rayyat.
No, admitted. Mechanically written statement, therefore I want to show Lordship. Para 9 and 10 of the written statement, Lordship. Once again, Lordship, mechanically. May I read, Lordship?
You just para number 7.
Para 7 of
Page
the-
7, page 7.
Yes, sir. Page 7. It is further
The defendant appellant further averred in the
The defendant appealing further ever influence the seat the date of survey settlement operation of this district in the year 1912 to up to date. The defendants are possession. So under the required occupancy right in the suit land. Now the defendant have filed titles to the realty settlement, and they no further remain the realty. The defendants later in the
So they denied their status as the Rayyat.
but in written statement is admitted I am the here. Para 9 tell Lordship mechanically it will be clear, Lordship. Para 9 may I read, Lordship? Written statement, Lordship, para 9 is there. Para 8, Lordship, of the written statement, Lordship. He also admitted that Gopal Sahu was the recorded Rayyat, Lordship. Admitted in para 7 of the written statement, Lordship.
Gopal Sahu died in the year 1948, leaving behind no legal heir.
Yes, but the plaintiff.
8 number.
Yes, the statement made in para 2 of the plaintiff is not wholly correct. It is a fact that before the survey and settlement operation, one Dhiru Mahato was possession of the suit land, and during the survey and settlement operation, he was rightly mentioned as a Rayyat in position. The recorded tenant recognized him as a Dar Rayyat.
You see, it is a fact that before survey and settlement operation, when Dhiru Mahito was in possession of the suit land, and during survey and settlement operation, he was rightly mentioned as Rayyat in possession. Now he says in the written statement that Gopal Sahu was a recorded tenant and he died in 1948.
Yes.
And thereafter, in the survey settlement operation, Dhiru Mahito was found in possession and he was the Rayyat in.
नहीं दर रैयत लिखा हुआ है.
He was rightly mentioned as Rayyat in possession. अब उसमें दर Rayyat हम कैसे सुन रहे हैं?
नहीं ये तो खुद ही लिख रहे हैं. The recorder idea recognize him as a दर रैयत.
Para 8, Padina, it is a fact that before survey and settlement operation, when Dhiru Mahito was in possession of the suit land, and during survey and settlement operation, he was rightly mentioned as Rayyat in possession.
And recorded Rayyat recognize him as a dar Rayyat.
The recorded Rayyat recognize him as Dar
Rayyat.
Okay, again, the statement of
the statement of the plaintiff falls to the effect that under right, it is like dar Rayyat, right is not maintainable, but the real fact is that dar Rayyat right of these deponents are heritable by custom. And the present plaintiff, who is not the legal heir of the recorded tenant, cannot challenge that defendant has no heritable right over the property. The tenant of Khata number 17, that is Gopal Sahu, had allowed the legal heirs of the Dhirit Mahatu, that is the son and grandson of him, to enjoy the property and remain in possession. So the present plaintiff had no right, interest, possession over the suit property. Gopal Sahu till his death never remained or came in possession, but is the defendant who was in possession of the title of the Gopal Sahu and after his death. Lordship, in this case, Lordship, in the year 1947, Lordship, Gopal Sahu Lordship executed a registered sale deed in favor of his Behna Lordship. Thereafter, Lordship, deed in Zamindar Lordship issued rent receipts Lordship, and after vesting Lordship, the Jamandi was opened in the name of the plaintiff Lordship, and the rent receipt is being issued in the name of the plaintiff Lordship. There is no document of the defendant that what is the legal paper of the title Lordship. And there is no pleading with respect to adverse possession Lordship. Lordship, I have given the several judgment that the Rayyat is not heritable, not transferable Lordship. And he said that there is a custom. Where is the custom? Where is the village not in which it has been mentioned that the Rayyat is a heritable?
If you frame an additional issue saying that whether the learned appellate court was right in holding that notice under section 106 was not required, you will hear all this during that argument. During that argument.
But according to us, Lordship, the suit for declaration of title and recovery of possession, the notice of under section 106 of the TP Act is not required, Lordship. Because there is no lease, there is no contract, he was only possession of the land.
You see, even in your plaint you say that he was appointed as Dar Rayyat. In your plaint you say that he was appointed as a Dar Rayyat.
I said that he was possession as a Dar Rayyat.
No, as a Dar Rayyat, and then he defaulted in payment of rent.
That is another thing, Lordship.
That is your plaint.
But it is not the relief of the plaintiff. The relief of the plaintiff for declaration of title and recovery of possession.
The status between the parties is to be determined on the basis of the plaint, not on the basis of the relief.
Yes.
In your plaint you say that he was orally appointed as Dar Rayyat and then he defaulted in payment of rent or advatai he did not pay. And in the written statement, they say that they are the Dar Rayyat. You say that they admit that they are the Dar Rayyat. So whether under such circumstances, a notice whether the learned first appellate court was justified in holding that notice under section 106 was not required.
But this is not the matter of the BBC Act Lordship. This is not a
106 notice का क्या 106 BBC Act में थोड़ी होता है?
Lordship, the 100 of the is applied only legal or contract Lordship.
तो contract oral नहीं हो सकता क्या?
No, maybe the contract is the oral. They have not stated that.
It is your case. You have talked about the oral contract.
I have not said. I only said that the defendants for the possession of the land.
Just a moment. आप अपना प्लेट खोल.
जी. पैरा 1 से पढ़ दो.
नहीं, पैरा 1 से पढ़ने का जरूरत नहीं है. यहाँ पे देखिए पैरा नंबर 9 पे.
The defendants are the agent and tenants at will. They are not paying the advertised rent for the last 2 years since January 1986. Plaintiff does not want to continue. The defendant will remain in possession of the suit land of the Schedule A of the third year. The plaintiff demanded possession of the suit land of Schedule A from the defendants who one person or other want a putting of the matter since last 1 year. Ultimately, when they are asked to vacate the suit land on 15/5/1988, they refuse to do so and challenge the title of the plaintiff over the suit land. Hence, it became necessary to institute
That's
the
right. So therefore, as per your claim, the status is that of a debtor who defaulted. So I'm repeatedly asking you, do you have a judgment to say that in case of default in payment of rent, not under BBC Act, but under Transfer of Property Act, notice under section 106 is not required?
sometime in given, I will definitely bring the judgment lawsuit.
Because 106 is not referring to any default. It is
Yes.
not referring to anything,
Correct.
right?
Correct.
In the plaint, you say that there was a default and therefore you wanted him to evict, right? Under such circumstances, is notice under section 106 of TP Act required?
Then also I will bring the judgment lawsuit. 1-2 days I will definitely I will bring the judgment lawsuit.
And if you are able to show me that
Yes.
even then it is required or not required,
Not required lawsuit.
then a law which has already been settled need not be settled again. I will not frame it.
Yes.
But if you are not able to show it, that law is required to be decided.
Yes. Correct. That sometime will be given lawsuit. I will bring the judgment.
1 घंटा 1.5 घंटा बहस करने के बाद मुद्दे पे पहुंच के आपको खुद ही नहीं पता है आपका एडमिटेड फैक्ट दर रही है, तो वो भी अपना हिसाब से बहस करते हैं, आप भी अपना हिसाब से बहस करते हैं.
नहीं I brought the judgment.
कम से कम फैक्ट में तो मत एरर किया करिए आप.
फैक्ट में हम लोग कहाँ हैं?
तो फैक्ट में ही आप बोले ना, it is not an admitted fact that he is a dadaiyya.
Yes.
It is an admitted fact that he is a
Dadaiya.
dadaiyya as per you, and he defaulted in payment of rent. Why have you taken this stand? You have taken a specific stand that he was a dadaiyya
I
under.
will bring the judgment. I will bring the judgment.
इतना टाइम नहीं दे सकते. लेकर आइए 1 बजे तक खोज. नहीं तो हम इसी पर इशू फ्रेम कर देंगे. इसी पर एडिशनल इशू फ्रेम कर देंगे that whether in second half में जजमेंट लिखा.
तो कर दिए फर्स्ट. एक दिन हमको रिटर्न किए हम ला दिए. नहीं वो खुद फेंक दिए उसको ट्रेन कर हम तो पूरा तैयारी करके हैं पूरा रिटर्न आर्गुमेंट में बना के लाए. रिटर्न आर्गुमेंट कल क्लियर कर दिए. एक दिन के लिए टाइम दिए थे. और क्वेश्चन भी लॉजिक अच्छा है.
और इस पे आपको क्या बोलना है बाकी उस पर?
But these issues are never raised before neither the learned trial court nor before the appellate court lordship, and so far the section 100 of CP is concerned, which is not permissible by law lordship. 100 of the CPC lordship, which is not permissible by law lordship. This we was taken first time before this honorable court lordship.
Which they are talking about misconstruction of 3 documents, Exhibit 2, 5 and 7. इसमें आपको क्या बोलना है? It's already there on recording. They say that 1 and 2 will merge with this. Whether the issue number 2 is vitiated on account of misconstruction of Exhibit 2, 5 and 7.
And then
2, 5 and 7 इनका 3 exhibits हैं.
so far is first additional proposal.
दोनों का एक साथ.
Is concerned lordship.
Decision in connection with issue number 2.
Issue number 3.
Yes. Of the trial court, no?
Appellate court.
Of the appellate court. Issue number 2 of
Issue
the
number
appellate
2
court.
is the registered two lordship, and issue number 4 lordship.
Issue number 2 is it? Exhibit 2, 5 and 7.
2, 5.
Page 21.
CC of the return lordship. The certified copy of the return lordship. The lordship, the gift deed executed by the Gopal Sahu in the year 1947 lordship, but it was recorded in the name of Gopal Sahu lordship. Although lordship in the year 1905 lordship, the CS record was prepared in the name of Gopal Sahu lordship. Therefore, lordship in record of right name of Gopal Sahu was mentioned lordship.
It is issue number 2 by the appellate court. Para number? Yes, Appealant, you are saying
Yes.
issue number 2. Where is it?
Yes, for paragraph 21, Your Excellency. And the issue framed by the appellate court is paragraph 6. Para 21 para 21 para 10 पे है इशू फ्रेम किया हुआ para 21 नेक्स्ट प्लीज
Registered 2 has been considered.
Exhibit
2
2
has
and
been
exhibit 7.
considered. Exhibit 7 has
Seven.
been considered.
Yes. These two documents and notes.
Exhibit deed of gift is not exhibit
Deed of gift is exhibit 8.
8, not 5.
But 5 I say it has not been considered. Because 8 को valid बोल रहे हैं on the grounds of exhibit 2 and exhibit 7. Exhibit 8 is a gift deed.
And exhibit 6 to 6 by 2, the Jamindari receipt lordship in favor of the plaintiff lordship.
That's it. So misconstruction of exhibit 2 and 7
Yes.
and non-consideration of exhibit.
exhibit. Exactly.
इतना ही है इनका issue number. Misconstruction of exhibit 2 and 7 and non-consideration of exhibit 5. जब एडमिट हो गया सब डॉक्यूमेंट्स देखने में क्या दिक्कत है? हो सकता है कॉन्क्रीट फाइंडिंग हो जाए या हो सकता है ऐसा हो जाए कि वन ऑफ द डॉक्यूमेंट्स में बिकम irrelevant.
You also may see exhibit 6 to 6 by 2.
That's right.
The Jamindari rents receipts.
Exhibit 5, right? Those have been considered.
And
But the
exhibit,
point,
and exhibit 1 by 1 to 1 by 4 lordship, the rent receipt lordship, after vesting lordship, the Jamandi was opened in the name of the plaintiff lordship.
that's it.
And there is certain principle of law that rent receipt is evidence of position of the land. I have given the judgment of the honorable
We'll see
Supreme.
that. We'll see that. It is just framing an addition.
But it is not that my submission is that no further additional substantial question of law is required. Because the exhibit 1 by 10, 1 by O is the rent receipt lordship after vesting, and before vesting the Jamindari rent receipts in favor of the plaintiff lordship.
the learned counsel appealing on behalf of the parties. RA number 13868 of 25. Sorry, IA number 15654 of 25 has been filed for claiming additional substantial question. The learned counsel for the appellant has submitted that the following additional substantial question of law is proposed to be framed. इसको quote करते हैं. The learned counsel for the appellant, while referring to the first and second additional substantial question of law, has submitted that the learned appellate court
Yes.
appellate court has misconstrued the exhibit 2 and 7 and not considered exhibit 5. By deciding issue number 2, he submits that for substantial question of law number, additional substantial question of law number 1 and 2, it would be sufficient if a substantial question of law be framed to the following effect: whether the finding of the learned first appellate court on issue number 2 is vitiated on account of misconstruction of exhibit 2 and 7 and non-consideration of exhibit 5. Right?
Consider.
Non-consideration of
It's
exhibit
considered.
5.
It is considered by the learned appellate court. Lord Sir.
Issue number 2.
Yes, Lord Sir, make page 20, Lord Sir. And you permitted to read, Lord Sir. Page number 20, Lord Sir. Considered by the learned first appellate court. एकदम नीचे बॉटम में, Lord Sir. Page 20, internal page 20, Lord Sir.
Yes.
Exhibit 5 से देखा है?
ये तो इशू नंबर 3 में ना, पॉइंट नंबर 2 में.
हमारे इसको कंसीडर किया.
अरे भाई कंसिडर किया है, लेकिन बाय डिसाइडिंग इशू नंबर 2 में नहीं कंसिडर किया. इशू नंबर 2 में इसको नहीं
इसको
कंसिडर
कंसीडर किया है इशू नंबर 3 में.
ठीक है, इशू नंबर 3 में
कंसीडर किया है.
2 में नहीं कंसिडर.
2 में नहीं किया, 3 में कंसीडर किया
I
है.
will see that. The learned counsel has further not pressed so far as additional substantial question of proposed additional substantial question of law number 3 is concerned. With respect to additional substantial question of law number 4, the learned counsel for the appellant has referred to the appellate court's judgment and has submitted that this point has been considered by paragraph 20 under point number Roman 5, and the learned first appellate court has held that notice under section 106 of the Transfer Property Act was not required. as the as the defendant had challenged the title of the plaintiff over the suit property. He has referred to the judgment passed by ये वही है क्या 1957 ये वाला जजमेंट कहाँ है BLGI 1959 पेज
Good.
ये जो रिलाई किया है वो कहाँ
जो रिलाई के नोट थे 59 पटना पेपर इंस्टीट्यूट
The learned counsel has submitted that the judgment which has been relied upon by the learned first appellate court which is also reported in AIR in 1959 AIR within bracket 380 bracket close 562 and has submitted that the same was arising out of landlord-tenant relationship under the special act, that is BBC Act, Bihar Land Lease Nampura.
and note here the facts are also different. The rent was being paid accepted by the landlord. The defendant atoned the notes the plaintiff as a landlord. They paid the rent. So straight away see page 5.
Where is BBC Act mentioned over here?
So,
Where is BBC Act mentioned over here?
the BBC Act mentioned here. So see page 5. Page 5.
ये BBC Act में था कि नहीं?
नहीं BBC Act में नहीं.
लेकिन आप बोले कैसा?
नहीं हम बोले पर लैंडलॉर्ड टेनेंट का डिस्प्यूट. What ये जजमेंट जो है इस पे लैंडलॉर्ड टेनेंट का डिस्प्यूट है. It is an admitted case here that rent was being tendered by the defendant to the plaintiff.
ऐसा मत लीजिए BBC Act में. It was an admitted case that there was a relationship of landlord and tenant.
And the rent was
And the
tendered.
rent was being tendered
By the defendant to the plaintiff.
by the defendant to the plaintiff. He submits that the finding that no notice was required to be issued under section 106 of the Transfer of Property Act is not in accordance with law, and accordingly a substantial question of law is required to be framed. The learned counsel for the respondents, while opposing the prayer, has submitted that
A suit for declaration of title and recovery of possession, no notice is required to be given.
has submitted that in a suit seeking declaration of title and recovery of possession, no notice under section 106 of the TP Act is required. He has further submitted that the defendant was claiming occupancy right over the property.
That is the fact also.
Occupancy with the
दोनों लिखे हैं दर रही है ये तो दर रही है तो thereafter he became the occupancy रही है.
has ultimately claimed that the defendant had occupancy right over the property, though at previous point of time he wasn't that.
दर रही है.
पहला वाला के लिए क्या बोलना है?
This point was
The learned counsel
raised before
the learned counsel has submitted that the point regarding additional evidences as argued by the appellant was never raised before the learned first.
It is a question of facts.
And the same is essentially a question of
Question of facts.
After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court is of the view that the exhibit it is a judgment of reversal is of the considered view that the exhibit two, 5 and 7 has important bearing in the matter. And exhibit 5 has not been considered by deciding issue number Roman 2 by the learned first appellate court, although it has been considered by deciding other issues.
Point number 3.
Other issues will come. Accordingly, an additional substantial question of law as suggested by the learned counsel for the appellant is required to be framed. Whether the मुझे ऊपर लिखा है ना same to same, whether the findings in connection with issue number 2 by the learned first appellate court is vitiated on account of misconstruction of exhibit 2 and 7 and non-consideration of exhibit 5. So far as the additional substantial question of law number 3 is concerned, the counsel for the appellant has not raised. So far as the additional substantial question of law number Roman 4 is concerned, this court finds that the suit was filed seeking declaration of title and recovery of possession, and the plaintiff had alleged that the defendant was put as the lawyer, but he failed to make payment of advertise/rent to the plaintiff, and on the other hand, the defendant claimed that they have acquired occupancy right in connection with the suit property. And denied the relationship as claimed by the plaintiff. This court is of the learned first appellate court by deciding point number 5, dealing with service of notice under section 106 of the Transfer of Property Act, has recorded that the defendant has denied the title of the plaintiff, and the plaintiff had filed the suit for declaration of title and recovery of possession, and therefore no notice under section 106 of the Transfer of Property Act was required to be served. Apart from the aforesaid, in the written statement also no specific plea was raised in connection with want of notice under section 106 of the Transfer of Property Act. इसको last time छोड़ दीजिए. This court is of the considered view that no additional substantial question of law is required to be framed with respect to the proposed substantial question of law number 4. अब क्या करना है?
Since your lordship has rejected my 106 point, but you have your 2 weeks time at least to challenge this test is all.
At this, the learned counsel for the appellant has prayed for some time to challenge this order before the Honorable Supreme Court and prays that the matter be posted after courts. Post this case on, okay? With the consent of the learned counsel for the parties, post this case on.
Your lordship posted was in month of January because Supreme Court is also not quite close.
Up 2 weeks बोले हम 2 weeks सुने.
But the 4th week then you are till
4
yes.
weeks. So after summer, after winter vacation. On 6th of January.
So may I see the record? Because that's what I mentioned.
Item 2, second appeal 559 of
एक किसी की
2023.
पास में करेक्ट यार एक किसी
ठीक क्या होगा?
एक किसी है उसको सॉल्व देते मिक्स हो जाता है सब 2 मिनट लगेंगे
Other side कौन?
यही
हम लोग
एक किसके लिए है थोड़ा सा करीब देख लेंगे 5 मिनट
अब इस जंगल में 2 ही शेर हैं तो क्या करें? कभी आप लोग इधर से उधर चेंज करते हैं, उधर से इधर करते हैं, बताइए। अच्छा इनको बहस करनी है, 5 मिनट के लिए क्या नियम करेंगे?
नहीं हम मान रहे हैं किसके लिए पासवर्ड कर दिए थे हम थोड़ा सा देख लेते हैं इसे तैयार है थोड़ा सा करीब हम मेरा नोट्स वाला वो देख लेना चाह रहे हैं तो मिक्सअप हो जाता है
ठीक है एक बात पूछिए। इसमें सब्सटैंशियल क्वेश्चन ऑफ लॉ तो फ्रेम क्या हुआ होगा ना?
फ्रेम ले लो
वही हम खोज रहे हैं कहाँ?
नंबर 15.
नंबर 17 से 2019 Whether the conclusion arrived at by the appellate court that there is previous partition reduce the evidence which had been reduced by the parties. Whether in view of fact that there is a presumption of jointness, it was incumbent upon the defendant responsibility to prove their case by reducing cogent evidence in support of their claim that there was previous partition of the property and fact. Whether in the absence of any evidence previous partition lower located to the committed and error and setting aside the degree of partition passed by the latter trial court.
आपको 5 मिनट टाइम चाहिए।
एक इसके की पास डेट
Of finance to item 3, second appeal 416 of 2018 along with item 4 and 5.
Second appeal 416 of 18. We received the notice, both the notice and recipient we have filed. Fifth, CR 448 of 2018. It's a no notice received by undertaken.
On behalf of whom?
पहला में रेस्पोंडेंट नंबर 70 and 80, फोर्थ में रेस्पोंडेंट नंबर 7 and 8, संजय प्रसाद सिंह।
अपीलेंट कौन है? आप हैं? बताइए क्या बोलना है?
4 और 5 में है।
क्या करें?
नॉट इसमें undelivered dispute post respondent 20, 21, 19B and 19C have been returned.
किसमें?
452 में 1 to 5 respondent number 1 to 5 appear हुआ है।
What is it? भाई आप बताइए, आपके भी मुझे कुछ समझ नहीं है। कौन सा रिकॉर्ड देखो?
448 serial number 4
448। ठीक है।
और 20 और 21 का आया है
19B, 19C and 20 and 21।
does not give उनका एड्रेस प्रॉपर नहीं है, ऐसा है। दूसरा 126 का जो नोटिस है वो गवर्नमेंट बैंक को जरूरत नहीं था। 7 to 8, 7 to 18 और 19B का अभी तक में सिविल सेक्शन में रिपोर्टिंग नहीं ये लिखी।
स्पीड पोस्ट का आ गया है ना? स्पीड पोस्ट तो आ गया है ना भाई?
The 7 to 18, 19 year have not received as yet.
और ये स्पीड पोस्ट का क्या रिपोर्ट है 7 to 18 का? स्पीड पोस्ट का क्या रिपोर्ट है विद रेस्पेक्ट टू 7 to 18? With respect to 7 to 18, speed post was issued upon them also, 7 to 18.
Yes.
What is the report in connection with 7 to 18?
It has not received as yet.
Speed post तो आ गया होगा ना रिपोर्ट?
It is the same.
Undelivered speed post of 7 to 18 and 19A has not yet been received.
तो इसको वेट किया जा सकता है।
Nothing has been reported about this speed post.
Undelivered report has not come. Speed post का तो ट्रैकिंग होगा ना? Undelivered registered coverage से क्या मतलब? That's got nothing to do with that.
ट्रैफिक रिपोर्ट को नहीं देखा वो रिटर्न होकर आया।
प्राप्तकर्ता नहीं रहते हैं इस पते पर। आप किनकी तरफ से अपीयर हो?
और 60 में
नहीं, पहले ऐसे 448 का बताइए।
448 and not yet received, no notice has been received. So far,
You want to? Then who are you?
in 416 and
448 का बात बताइए। Are you there in 448 or not there in 448?
I have no knowledge. Till now, no notice has been received. But so far, 16 and 52 is concerned. इसमें 17-18 है, 16 और 18 में, और 452 में 7 and 8.
भाई आप मिक्स मत करिए। You have no instructions to 448 बात खत्म। आपको जब तक नोटिस नहीं मिलेगा तब तक आपको अपीयर होने का क्या काम? छोड़ दीजिए। आप लोगों को केस डिसाइड थोड़ी कराना है। ये बताइए 416 में क्या इंस्ट्रक्शन है आपको?
416 में only this I have received only one page.
On whom? For whom?
For 17 and 18.
17 and 18.
18.
In both the cases,
Sir.
17 and 18 are the one and the same person.
17 Sanjay Prasad Singh and 18 is Mrinalini Saab in 416.
17 and 18. और जो दूसरा वाला केस है ऐसे 448,
4.
in that 11 is Sanjay Prasad Singh and Mrinalini Saab.
I undertake to appear in that also.
ऐसे नंबर 416 of 2018 मिस्टर नाम बताइए अपना।
नीलाकृष्ण मुखर्जी.
नाम लिख लीजिए। Has submitted that he has appeared on behalf of 17 and
Not yet
18.
appeared, but
He has appeared on behalf of 17 and 18 in essay number 416 of 2018. Appeared, not appeared.
not yet appeared, but
He has
total I have
received wakalatnama to appear on behalf of respondent number 17 and 18 in essay number 416 of 2018, who are Sanjay Prasad Singh and Mrinalini Shah respectively. He submits that he shall file wakalatnama willingly. So far as essay number 448 of 2018 is concerned, they are respondent number 11 and 12. He undertakes to file wakalatnama on behalf of respondent number 11 and 12 in essay number 448 of 2018. एक हफ्ता में
और 452 में भी है.
452 क्या है?
इसमें 7 and 8.
In essay number 452 of 2018, the aforesaid persons are respondent number 7 and 8.
Yes.
And he undertakes to file wakalatnama on their behalf in this record also.
Memo of appeal and other related documents may kindly be ready.
इसमें 7 and 8.
7 and 8. Sanjay
इसमें
Prasad
से 7 and 8 तो नहीं है संजय प्रसाद सिंह. 17 and 18 है इसमें. 452 में भी 17 and 18 है. 452 में भी 7 and 8 नहीं. 17 and 8. Now what else?
Copy.
कॉपी आप इनको दे दीजिए. अब नोटिस का क्या करना है बताइए आप लोगों को. क्या प्रपोजल है? किसको जाएगा? सबको हम फ्रेश नोटिस कर देते हैं. किसको किसको अपीयरेंस नहीं है और किसका किसका नोटिस नहीं है ये बताइए.
जिसका नहीं आया है वो 19, 20 and 21. इनके बारे में आया है कि ये एड्रेस करेक्ट.
अपीयरेंस भी नहीं है इनका.
एड्रेस करेक्ट नहीं.
और बाकी लोगों का 1 to 18
बाकी का 7 to 18 and 19 का कोई रिसीविंग अभी तक आया. इसको अवेट किया
सबका वही है.
448 में तो वही है.
The learned counsel for the appellant submits that the matter be adjourned, awaiting service report of some of the respondents which is still awaited. ठीक है? करेक्ट? कब रखना बताइए.
416 में certain का हम respondent से अपने पैरालेल A.
आप वकालतनामा फाइल कर दीजिए.
हाँ वकालतनामा फाइल किए 452 में. But 416 में we have to also appeal. 416 substitution हुआ है जिसमें ममता सिंह 10A, 10B, प्रसन्नजीत सिंह.
ऐसे नहीं चलेगा. आपको जिसमें अपीयर होना है अपीयर हो रही है. आप अगर नहीं करिएगा तो ये केस कभी नहीं डिसाइड होगा. आप नोटिस का कंप्लायंस थोड़ा वेट कर लेते हैं. नहीं तो अपना सब्स्टिट्यूटेड सर्विस करिए. क्या करिएगा? नहीं तो these matters will never be decided. ये नोटिस जाते रहेगा. Why should I direct? You have to say that you are not able to trace them, and then only there is a question of substituted service of notice. You have to say that you are not able to find out the present and correct address or whatever.
Yes, but so far as the 2021, 19B and 19CB, it has come in the endorsement that they are not there. But so far as the others are concerned,
एक ही साथ करेंगे ना सब्स्टिट्यूटेड सर्विस. बार बार हर एक का अलग अलग पब्लिकेशन कराएंगे तो आपका प्रॉपर्टी बिक जाएगा जिसके लिए लड़ रहे हैं, है ना? At one time and in one go the entire publication should be made. Piecemeal नहीं करना चाहते. That is not in your interest also. यहाँ पे नोटिस स्पीड पोस्ट का सबको गया था।
हाँ हो गया।
ये जो यहाँ पे ऑफिस नोट बनाए हैं, बाकी सबका ट्रैक रिपोर्ट क्यों नहीं है? थोड़ा उनसे पूछ के बताइए, उनको चेम्बर में बुलाइए। स्पीड पोस्ट का नॉन रिसीविंग और नॉन रिसीव नहीं होता है, स्पीड पोस्ट का ट्रैक रिपोर्ट होता है, ठीक है? और स्पीड पोस्ट का उसी तरह से इसका ऑफिस नोट बनाएंगे।
In 452 minutes, I have executed वकालतनामा।
आपका जिसको वकालतनामा फाइल कर दीजिए, उसके लिए ऑर्डर की कोई ज़रूरत नहीं है।
इसमें अगर नहीं अगर ये अपेयर करेंगे या इनका अगर कोई वैसा ट्रैक रिकॉर्ड है तो 5 और 520 का
आपको जो मर्जी हो करिए, लेकिन लग नहीं रहा है कि ये हम लोग के लाइफ टाइम में इसका नोटिस सर्व हो पाएगा। कहाँ एप्लिएट? आप ही बताइए, आप ही बता दीजिए कौन कौन एप्लिएट है, हम दिखा देते हैं। आप लोगों को पता ही नहीं रहता है। हाँ, तो जो एप्लिएट है आप लिखा दीजिए, इनको दे दीजिए कि दे हैव ऑलरेडी एप्लिएट बाय फाइलिंग वकालत। हमको तो नहीं पता चल रहा, हम लोग का ऑफिस नोट जो लिखते हैं आजकल, दे आर एब्सोल्युटली अनट्रेन्ड पीपल। You just give the learned counsel for the appellant has submitted that the respondent number such and such have already appeared in case number such and such. तीनों केस का लिख दीजिए जो ऑलरेडी appear हो चुके, ठीक है, बाय फाइलिंग वकालत। नेक्स्ट डेट बताइए कब दे दें आप?
बोला उनका आज अपना ट्रैक रिकॉर्ड, उसके बाद आई विल टेक स्टेप फॉर सब्स्टिट्यूट इट 2 वीक्स के बाद
8 दिसंबर।
एक अमेरिकन का भी डेथ हो गया है, अमेरिकन नंबर 2 इंस्टीट्यूशन
दोनों सब केस में
हमारे केस में तो 2 अमेरिकन नंबर 2 दूसरा वाला
किसके केस में? भाई हम ऐसे कैसे लिखेंगे? किस केस में कौन एप्लीकेंट बताइए, नाम बताइए, नाम बताइए। देवेन DEVAN VEN। The learned counsel for the appellant has submitted that one of the appellants, namely Deven Bhandari, has expired. When?
on 16th of August 2025.
On 16 August 25. आइए नेक्स्ट डेट में आएगा
I will take this.
और पहला वाला
Password case item 2, second appeal 559 of 2003. Item 2.
This is the 22nd appeal against the judgment of a province. The plaintiff filed title suit claiming half share of the suit property lawsuit. Suit was dismissed against filed first appeal, which was also dismissed against this. The second appeal has been filed as sufficiency question law claimed by this court laws.
On what ground it has been dismissed?
But actually it is not a person was decreed. He won in the first.
Yes. So
This is wrong.
So the
It was decreed. Appeal.
Yes. This is my mistake. Reversal.
Appeal allowed.
Appeal allowed. Suit was decreed.
Plaintiff is the appellant.
Yes.
Okay.
Yes. Notion is required to notice facts of this case also from the judgment of the first appeal court.
No, what is the ground? What is the ground on which the appeal was allowed?
The appeal was allowed on the ground that there was a previous partition lawsuit.
The previous party.
The previous partition. And like
What was the mode of partition? as per
Your
the
lordship,
appellate court?
and second law is
Oral or registered or what?
the oral laws, oral laws.
Followed by separate possession?
Yes. The case of the plaintiff is
Just
that
एक second, थोड़ा basic question, partition suit है, basic question है ये, followed by separate possession. And rent receipts also?
no, rent is
Followed by separate possession.
Separate possession.
The possession was equitable or it was absolutely looks like it?
nothing equitable laws.
What is the tentative date of oral partition?
I am telling you, but some fact is also very.
Tentative date, year, century, कब का oral partition?
इनका कैसे की पार्टीशन हो चुका है, हमारा कैसे की
हम
पार्टीशन
फाइनलिंग ये पूछ रहे हैं, हम समझ रहे हैं आपकी बात। लेकिन एप्पलेट कोर्ट को आपने असेल किया है, हम एप्पलेट कोर्ट के बारे में बेसिक
एप्पलेट कोर्ट हम लॉस किया।
You have lost, and that is why you are here.
Yes.
Right? So I just want to know, as per the appellate court's judgment, when did the oral partition take place? जिस फाइंडिंग को असेल करना है उसको अच्छे से समझने तो दीजिए ना, कौन सा फाइंडिंग है? Just give me a tentative date, and then I will just let you out.
Para 9 of the written statement, date has not been mentioned, but it has been stated that soon after death of the Buddha Ram, his two sons, Bandhu Ram and Teko Ram, separated themselves in May's residence and cultivation.
डेथ कॉमन एंसेस्टर का डेथ कब है?
कॉमन एंसेस्टर का डेट भी नहीं लिखा हुआ है।
डेट नहीं, ईयर लिखा है, सेंचुरी लिखा है, सेंचुरी भी नहीं लिखा।
कुछ नहीं लिखा हुआ।
मतलब 19th सेंचुरी में मरे कि 18वीं सदी में वो भी नहीं लिखा।
तो सब फैक्ट्स बता देते हैं। वैसे बुद्धा ram was the common ancestral lordship.
And let me see the substantial question.
Yes.
पढ़िए।
Order number 15 lordship. Whether the conclusion arrived at by the appellate court that there was a previous partition is against the evidence which has been adduced by the parties. 2. Whether in view of fact that there is presumption of jointness, it was incumbent upon the defendant respondents herein to prove their case by adducing cogent evidence in support of their claim, and there was a previous partition of the properties. Whether in absence of any evidence in relation to previous partition, lower appellate court has committed an error in setting aside the decree of the partition passed by the latter trial court. The case of the plaintiff is that the Buddha's Puram was the common ancestor of village Kahirampur. Buddha Puram.
You are reading from the appellate court judgment?
Yes.
But
May I read?
yes.
Para 2 lots. The case of the plaintiff in short is that Buddha Ram of village Bahirampur had two sons, namely Bandhu Ram and Teko Ram. Bandhu Ram died before the last survey settlement operation, leaving behind Bandhu Ram and Teko Ram in his legal years. Bandhu died in about years 1956, leaving behind the defendant's father Chattu Ram, and in the legal years and Teko Ram died in about 1954, leaving behind the plaintiff as a legal year. The detailed genealogy has been given at the foot of the plate. It is further said that lands of Khata number 45, measuring area 5.64 acres of the village Bahirampur, was recorded in the name of Bandhu Ram, who was the Karta of the family. At that time, Bandhu Ram and Teko Ram were living separately. It is further said that
Living jointly.
Sorry. It is further said that after family was expanded, the plaintiff's father constructed a separate house in Bangalore town. But the lands of Khata number 45 remained joint, and both the plaintiffs and defendants cultivated the same jointly. After the history of the lands of Khata number 45 to the state of Bihar, the fathers of the plaintiff and fathers of the plaintiff number 1 were recognized as a joint unit by the state of Bihar, and Jawandi was opened in joint name of the plaintiff and defendant number 1. And they were found in joint possession thereto. It is further said that in the year 1939, Bandhu Ram sold 0.40 acres of land by Khata number 45, lot number 940 to the so area of 5-16 acres of land in Khata number 45 remained in joint possession of the plaintiff and defendant. The details of the suit land has been given in schedule 1 of the plan. It is further said that plaintiff and the defendants were cultivating the land jointly, and the plaintiff paid the rent to the estate of Bihar on every alternative year, and defendants also paid the rent in alternative. Last rent was paid by the plaintiff number 1 on 38 of 3/1994. It is further alleged that in view of the differences between the parties, it was not possible to keep the land joint because the defendant wanted to grab the genuine share of the plaintiffs and to dispossess the plaintiff from the suit land forcibly. So plaintiff demanded partition of the suit land through the panchayat of the several locations, and Panch also directed to share the land equally, but the defendants were not ready to do so amicably, hence the suit for the said relief. After issuance of summons and reading para 3, the case of the defendant is that suit is not maintainable. Plaintiff has got no power of bring the suit apart from the above. It has been contended that suit is barred by law of historical waiver and increases that the suit is title suit is in nature for which the adverse court fee ought to have been paid, but in the garb of the title suit, partition suit has been brought. Immediately, as per the written statement, the land of Khata number 45 measuring in area 5.64 acres were recorded in the name of Bandhu Ram, who is the ancestor of the defendants, as is apparent from the genealogical table. It is false to say that he was the Karta of the family constituted by himself and his brother Teku Ram, and that after death of their father Bandhu Ram and Teku Ram separately themselves in maize residence and cultivation. It is also denied. It has been alleged that said disputed land was acquired by the own income of the Bandhu Ram. It was accordingly recorded in his name in serious settlement. The Khata number 45 never remain joint between the plaintiff and defendant as well as their ancestor Bandhan and Teku Ram. At that no ceremony was opened, rather the collusion of the ancient office. Some rent receipts were obtained by the plaintiff party had advocated the stage that the Bandhu sold 0.38 acres of the land Khata number 45 to Meena Tirki, but it is also false to say that remaining land of 50 point something acres of said land remained in joint possession of the plaintiff or defendant. The Bandhu Ram remained in exclusive possession of the disputed land till his death. And after his death, the land came in possession of the Chhatta Chotu Ram, defendant number 1, and his son, defendant number 2 and 3. During the presidency of the same defendant, Chotu died, and after his death, said land was inherited by defendant number 2 and 3, and they are legally in possession over the same, whereas the plaintiff had no possession of the same. The defendant claimed to dismiss the appeal. The court not to make any issue claim as an
No, I just want to know, the plaintiff, the common ancestor was Buddhanoram.
Yes.
And according to the plaintiff, it was recorded in the name of Buddhanoram.
Budhura.
Buddhanoram.
The Buddhanoram had 2 sons, Lordship.
That's right. But as per the defendant, the property was recorded in the name of Bandhuram.
Yes, Bandhuram, but rent receipt.
No, Bandhuram.
Rightly.
No, it was. You see, the story of the plaintiff starts from Bandhanuram, and the story of the defendant starts from Buddhuram.
Yes, Budhura is the recorded tenant, Lordship. In record of right, name of the Budhu was recorded, but name of the and the.
No, you see, the written statement says that the recorded tenant is Bandhuram and not Buddhuram.
But the Budhura Lordship had 2 sons.
Maybe he has 2 sons.
Budhanura, sorry. Budhanura had 2 sons.
Buddhanurao had 2 sons,
Two
but
sons.
the land is not recorded in the name of Buddhanurao. It is recorded in the name of Bandhuram.
Bandhura, But land system is also recorded in the name of Bandhuram and Tekoram. I am the descendant of the Tekoram, Lordship.
So the recorded tenant's name, as per the plaintiff and the defendant, are not one and the same. As per the plaintiff, the recorded tenant was Buddha Rao.
Buddhan was the father. He had two sons,
Yes.
but one is Bandhu,
Bandhu
and
and
one
Teko.
is Teko.
Okay.
In the record of right, it is mentioned Bandhu. That is the ancestor of both cases.
Okay. So,
It is Bandhu.
so the common
Record of
ancestor is Bandhu Rao.
The common ancestor Buddhan.
Buddha.
That's right, but the recorded tenant is Bandhu Rao.
Exact. Defendant के तरफ से जो है.
तो plaintiff and defendant का कौन कौन represent करते हैं? They are the descendants of.
But plaintiff को plaintiff जो है टेको के वंशज है और defendant जो है बंधु के वंशज.
Plaintiffs are descendants of
टेको.
Tekoram.
and
Defendants are वंशज of बंधु.
defendants
who is the
are
recorded.
Bandhu.
Yes.
और टेको और बंधु दोनों सगे भाई.
दोनों भाई.
सही है. Lord, make anything right.
If the property is recorded in the name of Bandhu Rao, then how the descendants of Teko Rao will take a share in that property?
Lordship, it is a joint property, Lordship, because
From where? That is why I'm looking at the common ancestor. Joint property कहाँ से शुरू हुआ है? यहाँ से बुद्धन राव से तो joint property शुरू नहीं हुआ.
But it is the property of the Buddha because of those source of acquisition of land has not been mentioned, Lordship.
So
Source
the source of acquisition is not.
The record of right is not a document of
No,
title.
not a
Lordship.
document of title. But what is then merely because a property is recorded in the name of the son, does that mean that it belongs to his father?
But Lordship, the acquisition of land has not been mentioned, Lordship.
Need not be.
Lordship, make any say, Lordship, WS, Lordship, admitted, Lordship.
That's right. We have read the written statement from the appellate court judgment. But this was a query I just wanted to know.
Yes.
Land is recorded admittedly in the name of one of the sons.
One of the sons, correct?
Are you finding for you?
Lordship, I am coming to the tripod issue.
Tripod
related
issues.
tripod. Paraful of issue claimed as a level tripod.
सूट कब का है?
Suit है 94.
Para number 4.
4. If the suit is maintainable in the present form, have the plaintiff any cause of action for the suit? Is the suit barred by limitation? Is the suit barred by law waiver and imprisonment? Those will issue important 7 and 8. Is the suit property joint into family property and plaintiff has both title over the suit land and whether there is unity of title and possession between the parties. Lordship, the main issue is the issue number 6 and 7, para 6 laws. Para 6. These two issues relates to the fact and related. So they
Just a
are
moment. Issue number 6
and
and
7.
7.
Para 6.
Right. Para 6. Okay.
Yeah. These two issues relate to the facts and are related, so they are taken together for consideration. It has been case of the plaintiff that land of khata number 45, an area of 5.64 acres, was recorded in the name of Bandhu Ulam, who was the Karta of the family, and Budhan Ulam has died before the last survey and settlement operation, leaving behind his two sons, Bandhu Ulam and Teku Ulam. As they were years at that time. The Bandhu Ulam and Teku Ulam were living jointly. After the family was expanded, plaintiff's father constructed a separate house in Bangalore town, but the khata of 45 remained joint by the plaintiff and the defendants cultivated the same jointly, and after vesting land of khata number 45 to the state of Bihar, the father of the plaintiff and father of defendant number 1 were recognized as a joint tenants by the state, and Jamabandi was opened in the name, joint name of the plaintiff and defendant number one. So they were found in joint possession thereof, and in the year 1939, Bandhu Ram sold 0.40 acres of the land of Khata number 45, plot number 92 on Mira Tirki, an area of 5.16 acres, remained in joint possession of the plaintiff and defendants. Whole. It has been the case of the defendant, the Bandhu, out of his own income, acquired the lands of Khata number 45, which was accordingly recorded in his name in a settlement operation. Besides this, he also acquired the several Rayati lands, which were settled in Rayati in his name, and Bandhu Puram was recognized as Devabandi also was opened in the name of Bandhu Ram Deva, and Bandhu Ram was the position of the land of Khata number 45. If the plaintiff produced any paper saying the Jamabandi in the name of the Teko Ram, it must have been obtained in collusion with the Anchal staff. In this connection, I feel that the evidence of the plaintiff, namely Mira or PW6, the evidence of defendant number 6, is the most important piece of evidence, and the document filed by the party, because we have to see the first that whether the plaintiffs have supported their case as made out in the plaint. The PW6 came out is
Supported their income as made out in the
supported their income. पुराना है कार्ड दिखा रहे हैं as the made out in the plaint. The PW6 Pema Ram has said in his evidence that Bandhu Ram was only elder brother of his father, and Bandhu Ram had only one son, Chatu, and Teko had two sons, Pema and D. Hans. And the Bandhu Ram died when he was 6 to 7 years old. Teko Ram, his father, died after 5 to 6 years. After his death, at that time, they both living jointly of the elder brothers were the Karta of the family. After death of his father, due to extension of the family, they started living separately. But there was no partition between the plaintiff and the defendant. And they divide the share of the crop 50-50. And Khatyan of the land is recorded in the name of Bandhu, but in the Anchal Jamabandi was opened in the name of Teku and Bandhu, and the defendants both take rent receipt. He denied the fact that Bandhu has acquired the lands alone. The genealogy has not been challenged, thus it is established that the Bandhu Ram was the woman in Bandhu Ram, the woman in sister of the plaintiff and defendant. They also said that his father, after return from the military service, settlement of said Dharmajuva land, and after taking settlement house was constructed in Bangalore, Tola, and his brother constructed their separate house. He said that his father was living Balrampur and Korha, both. He was also residing in Korha with Bandhu Puram. He has also said that there were 14 plots in the suit land, and has also said that about the area of 15 point something acres land which was situated in places. The DWC, Deveshwar law, had said that in his evidence that the suit land belongs to Khata number 45 from the Boharampur, but it is the written as a Boharampur. Yet the land of Khata number 45 was recorded in the name of Bandhu Ram, and after his death, the land came in possession of the Chotu Ram, and after his death, the same came in possession of the defendant. He has said that Bandhu Ram used to pay the rent, Zamindar, and after vesting, used to pay the rent to the government. After his death, the Chotu Ram paid the rent to the government, and after his death, paying rent to the state. It is also proved that high Zamindari receipt marked at exhibit B, B by 1, B by 2, B by 3, B by 4, but the defendants have not record any sheet of paper to the to show that how the above land is acquired Zamindar before the scheme, nor there is any pleading or evidence on the record to show that acquisition of said land from the Zamindar law. So this is important law. DW6 has categorically said that in his evidence that he has been the paper in the answer which is in the name of Bandhu. He also seen the register too. And in register to name of Hema has been illegally added. He took a step in the Anchal order was passed in his favor, which is good file, but no such documents has been filed by the defendant. He also admitted that name of the Hema and Hema from the Hema was not from the register to he exhibit to filed the plaintiff has also clearly shown that order was passed in the miscellaneous case number so and so, dated 26/6/1984 to issue the rate receipt with respect to the khata number 45, area 5.15 acres of Balrampur in the name of heirs of the Katyani Regal, namely Shatu Rao, son of Bandhu Rao, and Nema Rao, and son of Teku Rao, after correcting the name of the said land and the amount of land, the defendants have not filed any document to show that the above order has been set aside or modified. Accordingly, the rent receipt produced by the plaintiff and marked as exhibit 1, so and so, that same has been issued by joint name of Shatu Ram, Pema Ram, Lima, who are the defendants of the common interest. Exhibit 1, A to Exhibit 1 by 15 says here that same was issued with respect to the area of 4.20 acres of land of khata number 45, and for which the correction waiver miscellaneous case has been filed with the plaintiff. The rent receipt, that is Exhibit 1 by 165 of the defendant, itself clearly 5.9 show that same has been issued in the name of Shatu Ram Vagera on 11/3/1994 before the death of the Shatu Ram. As the Shatu Ram died on 3/12/19, so the Vagera for this, namely Tema and Nema, since the plaintiff have alleged that suit property is a joint family property, the defendants contradictory itself acquired property. The until the it is proved the joint and boundary line was also another claim that the property is in his separate property, but the defendants have not brought on record any evidence to show that mode of the acquisition of the said. This is my submission. Said land by the Bandhu Ram alone. No doubter the Katyani has been filed by both the parties and marked at Exhibit 3 on behalf of the plaintiff, Exhibit C on behalf of the defendants. A khata number 45 has been recorded in the name of Bandhu Ram, son of Budhan Ram, the elder brother of the taker. So Bandhu Ram, during the registrar survey and settlement operation, without any document of right title interest and exclusive possession about the Katyan, Exhibit C recorded in the name of Bandhu Ram, neither clears any right nor extinguish the right unless devoted. It is also well settled that record of right is not a document of title. Right? In such document do not prove the exclusive title of the person so recorded. And it is also well settled that rate receipt issued by the state of Bihar without prejudice are not perfect proof of title and possession because they are issued with the same. It was only momentary transaction between the person and the state payment of rent by that person to the state would not have any legal binding effect on another. Since the Devabandi has been created by several of the Chattura, the father of the defendant Nema Ora is admitted by the defendant himself, and order has been passed to issue rent receipt in the name of the above person with respect to land of Khatan No. 45, effectively to him the existence of jointness, exception of the joint family property with respect to Khatan No. 10, cannot the normal state of every Hindu family is the joint property. Every family in the joint is the, and in absence of proof of the division, such is the legal. It may be the direct evidence of the prior partition, but the defendant has failed to prove any prior partition, as none of the witness of the defendant has said that prior partition while the rent receipt produced by the plaintiff cannot, the rent receipt agreed on by itself so that they have been issued is joint name of the plaintiff and Chattur, father of the defendant, and this shows that the joint possession of the both the land.
The trial court has primarily gone into the joint possession,
Yes,
but not on the point of title.
joint possession. The trial court has not gone in that title clause.
Trial court has not gone into the title
Yes.
of the property.
But the rent receipt clause is jointly issued clause. The source of acquisition has not been mentioned. In one thing is important clause to make and see the retail statement clause. Para 9 laws. It is submitted that soon after death of the Buddhanava, his two sons Bandhu Ram and Eko Ram separated themselves in mess, residence and cultivation, and Bandhu settled himself at the village Bairampur. Similarly, Eko settled himself as a Bagalwar. But he admitted also. He says that the Bandhu and Eko have separated themselves in mess and residence.
That's right.
Meaning
See,
that
there could be a joint family. But does that mean that it's a joint family property?
No, see, today only brought the separate place and separate residence is not a proof of partition.
The appellate court has held that there was a previous partition.
No, it is should have been decreed in my I am the plaintiff.
Appellate court, what the appellate court? Must have said that it's a self-acquired property of
The
Bandura.
appellate court says that the record of right recorded in the name of Buddha Sahu.
Record of right was never prepared in the name of father of Tekoram and Bandura.
Yes.
What is the reason? Who acquired this property?
Maybe some reason, because
No,
the
you see-
Buddha Sahu, the Karta of the family, therefore,
How do you get-
record of right was recorded in the name of
No,
Buddha.
the Bandhu Sahu
Bandhu
was
Sahu.
Karta of the family.
Yes.
But how did he acquire the property? When did their father die?
Before survey operation, CS survey operation.
Before survey operation.
CS survey operation.
Okay. And since when they are in possession of the property?
Position of the property loss is after the survey of operation loss.
What is the appellate court's judgment? Yes. What are the issues? What are the points framed by the learned?
Issue are framed by the learned first appeal court.
What issues?
Para 5 laws. Page 40.
Just Para 5.
From the provision of the
Yes.
document, the main issues are follows. The issue number 6, 7 are that the joint Hindu property and plenty of court title over the suit land. whether there is a unity of title in possession between the plaintiff and defendant. One, A. B. Is the plaintiff is entitled to release plate or to another release or release law.
There is issue number, this one, the first one, issue number 6 and 7. Where is the finding?
Findings. Para 28 also, page 60, internal page 60. Para 28. I find that respondents have not been able to prove their title and possession of the suit land as the member of joint Hindu family, and have also not been able to prove that his forefather Teko was in possession of the disputed land recorded in the name of his father Bandhu, and Bandhu was the Karta of the family. Plaintiff has also not been able to prove that his ancestral house was Bahrampur, whereas the appellant defendant has been able to prove that the forefather Bandhu had a house at Bahrampur in which they are continuing their residence, and their property was solely owned by his forefather Bandhu. Since I find that appellant defendant has possessory title over the suit land, I find that in judgment of the Government Court issue number 6 and 7 suffering from material. As regard the issue number so and so finding as
Para 26 पर.
Para 26. From the picture of the exhibit 3 shows that plot number so and so is required by the Bandhu now as Jina Rayat under for the past investigation case number under section 85 of CTA. This evidence so clearly shows the appraised plot number 163 where required by the Bandhu now, and there is no question that plot number Khata where ancestral property were acquired by the joint family. It was supervised by the Bandhu as a Karta.
What is the evidence to show that Bandhu had acquired the property as a Karta? What is the evidence? Because the property is recorded in his name.
Correct.
From where do you say that the property was acquired by him as a Karta and he had acquired the property from the joint family property? ऐसा कहाँ है?
Plate number लिखे.
प्लेन से नहीं एविडेंस दिखाइए ना. प्लेन में तो लिखे ही हों. If the property is recorded in the name of a particular person, then that property is assumed to be his own property, unless it is rebutted by evidence.
Correct.
Right? Where is the evidence to show that he acquired the property merely because he is the Karta? That does not mean that he acquired the property from joint family funds.
The evidence in Para 99 laws, page number 6.
Yes.
The PW1 has stated that the disputed land is 5.6 acres situated in 12 plots in which the plaintiff, Irma and Nirma, and the difference have half and half there. He stated that disputed land is the ancestral land and his position of the plaintiff had Para 1 be evident. Thus the blood from the result of the close examination in Para 2, it is apparent that his PW would not tell the Khata number, plot number of the boundary of the disputed land. He has not been able to tell in whom the name.
He has not been able to tell
Able to tell in whom. The
in whose name.
Whose name the rent receipts are being issued. Then if the accounts of the said land as the position of the plaintiff given by the PW examination, it does not remain relevant. This PW has stated that present plaintiff are not the cultivatory position of the land. It is my guess.
Yes.
It is my
तो आपके अगेंस्ट नहीं बोला. आपका ना पोजीशन है ना टाइटल है ना कुछ. आपका एविडेंस ही आपका अगेंस्ट में.
evidence.
आगे बढ़ते इधर आपका फिटनेस आपके अगेंस्ट में बोल
Very against me, but
सब अगेंस्ट में है ज़्यादा टाइम पड़ी
but
तो क्यों आप लोग ये सब्सटेंशियल क्वेश्चन ऑफ लॉ बनवा के बहस कर
to do gossip, I have
ड्यूटी
duty PW
मतलब जब कोर्ट से फ्रेम हो जाए तो सब ऑनरेबल कोर्ट के नाम पे डाल दीजिए कि उन्होंने फ्रेम कर दिया अब तो मेरे पास कोई ऑप्शन नहीं है बहस करने के अलावा
PW2. Janaki Ram Vijay was showing so he has stated that that disputed situations in Bahrampur has further stated that state land has not been partitioned and has said the state land was in position of the Telangana by in the evidence and examination. It is clear that PW has not disclosed the position of the respondent. He admitted the case of the plaintiff. Also, he has stated he does not know in whose name papers of land are who give in the rent of land. He has further admitted that he does not know the number of the entry in disputed land. He has stated that he knows the judicial Nago, son of Chatu, is grandson of the Bandhu Ram, and he stated they are in possession of the disputed land. The evidence appears to confirm the position of the defendant, not the plaintiff. In the further lines, he stated that he cannot say on which plot am I in position. His evidence is para to confirm the position of the appellant defendant. He has not stated about the joint position of the Bandhu. So, we must do that.
But इनका प्लेन में भी केस नहीं है कोई न्यूक्लियस का।
That's very interesting. ठीक है।
प्रीवियस पार्टीशन का कंक्लूजन कहाँ है आप एपलेट कोर्ट का
अपीलेट कोर्ट में
इज देयर एनी फाइंडिंग ऑफ प्रीवियस पार्टीशन का तो कैसे नहीं ये सब्सटेंशियल क्वेश्चन ऑफ लॉ कैसे बना whether the conclusion arrived at by the appellate court that there was a previous partition is against the evidence तो किसी का केस ही नहीं है कि प्रीवियस पार्टीशन हुआ is there any finding Roman 2 तो इसका हम यही लिखा है that there is no finding and you admit that there is no finding substantial
हमारे एडमिशन में नहीं
दिखाइए आप हमको हम एडमिशन की कहाँ बात कर रहे हैं आप दिखाइए हमको there is a finding of previous partition
देख लेते हैं।
But previous partition में तो तब नंबर जब मानेंगे कि joint तब partition यहाँ मानेंगे joint है तो वो मेरा independent है
और इंडिपेंडेंटली रिकॉर्डेड है और ऐसा केस ही नहीं है कि पिताजी का प्रॉपर्टी था मेरे नाम से रिकॉर्ड करा लिया
और इसका प्लेट में ये भी केस नहीं है कि फैमिली का न्यूक्लियस था सफिशिएंट फंड था जिसे ये खरीदे अपने नाम पे इंडिपेंडेंटली ये भी केस नहीं है प्लेट
और कब खरीदे वो भी नहीं
ये खाली रसीद के बेसिस पे जो है हो गया और कुछ नहीं
तीनों सब्सटेंशियल क्वेश्चन ऑफ लॉ प्रीवियस पार्टीशन का बना फाइंडिंग है ट्रायल कोर्ट एपीलेट कोर्ट का प्रीवियस पार्टीशन का
because there is no case of jointness को तभी हम previous partition हो गया and therefore the property is now not liable for partition because of the fact that previous partition
ये तो डिपेंडेंट ने केस ही नहीं बनाया
Defendant
डिपेंडेंट बोल रहा है मेरा इंडिपेंडेंट टाइटल
हाँ मेरा सेल्फ एक्वायर्ड
दिखाई
प्रॉपर्टी
जरा।
मेरा नाम प्रॉपर्टी
ये रिटन स्टेटमेंट दिखाइए ऐसे तो नहीं एज्यूम करेंगे ना तीन सब्सटेंशियल क्वेश्चन ऑफ लॉ बना हुआ है ऑन द पॉइंट ऑफ प्रीवियस फाइंडिंग दिखाइए प्रीवियस पार्टीशन हाँ आप बोलते हैं कि प्रीवियस पार्टीशन तीनों का सब्सटेंशियल क्वेश्चन ऑफ लॉ इज ऑन प्रीवियस पार्टीशन वेयर इज द फाइंडिंग ऑफ प्रीवियस पार्टीशन एंड वी विल स्क्रूटिनाइज दैट फाइंडिंग इनफैक्ट इशू भी नहीं बना है प्रीवियस पार्टीशन पर. There is no issue framed on previous partition.
Parallel in there not WS. The C statement is self-required for pure dependence. Partition like marking.
तीनों इशू प्रीवियस पार्टीशन पे बना हुआ. नहीं है ना प्रीवियस पार्टीशन का कोई फाइंडिंग. इतना ही लिख देते हैं कि प्रीवियस पार्टीशन का कोई फाइंडिंग ही नहीं, एंड देयरफॉर दीस क्वेश्चंस डू नॉट अराइज. इनका सबमिशन लिखा देते हैं.
कुछ है नहीं, कुछ अंदर हम लोग को नहीं, थोड़ा सा बाहर निकलने का ऑप्शन देखते हैं वहाँ पे. आजकल सब ऑनलाइन है, सब वीडियो में रहते हैं. आप क्या बस वीडियो तो ज़्यादा दिक्कत हो रहा है.
दिक्कत हो रहा है कंसीड करने में,
कुछ बोलने में भी दिक्कत है.
कंसीड करने में.
हाँ, कुछ बोलने में भी दिक्कत है.
तो आप तो जस्टिफाई कर दिए, पूरा बहस कर लिया.
बिल्कुल इसी का
Then I will just record that in absence of any finding of previous partition, these substantial question of law do not arise for consideration. From your submissions, I will record that. ठीक है? देखिए essay number 559 of 2003. Heard the learned counsel appearing on behalf of the parties. This appeal has been filed against the judgment dated 9th of September 2003 within bracket, decree signed on 39/2003 bracket closed, passed by learned 9th additional district judge Hazaribagh, whereby title appeal number 15 of 2003 has been allowed, and the judgment and decree dated 31st March 2001 within bracket, decree signed on 25/4/2001 in partition suit number 97 of 94 / supplementary number 157 of 98 has been set aside. The learned counsel has, for the appellant, has submitted that the partition suit was decreed था ना?
Yes.
Was decreed, and the learned first appellate court has allowed the appeal and consequently the plaintiff is the appellant before this court. The learned counsel has submitted that it is not in dispute that Budhan Urao, B-U-D-H-A-N, Urao, had two sons, Bandhu Urao and Teko Urao. And the plaintiffs are the descendants of Teko Urao and defendants are the descendants of Bandhu Urao. He has also submitted that it is not in dispute that the suit property was recorded in the name of Bandhu Urao.
Yes.
However, the plaintiffs sought partition over the suit property. In which the suit was decreed. The learned counsel for the respondents, on the other hand, at the threshold, has submitted that none of the substantial questions of law as framed by this court by the order dated 17/6/2019 arise for consideration, as all the substantial questions of law are relating to previous petition. The order dated 17/6/2019 framing the substantial questions of law are quoted as under. The learned counsel has submitted that it was never the case of the defendant that there was any previous petition, nor there is any finding by the learned first appellate court regarding any previous petition with respect to the suit property. Rather, the specific case of the defendant was that it was their self-acquired property and the property stood recorded in the name of Bandhu Urao. To this, the learned counsel for the appellant was called upon to point out any finding from the learned first appellate court on the point of previous petition, which the learned counsel for the appellant has failed to point out before this court. This court has also gone through the appellate court's judgment and finds that there is no finding of any previous petition by the learned first appellate court. While allowing the appeal, rather the learned first appellate court has recorded a finding that the plaintiff have not been able to prove their title and possession of the suit land as a member of joint Hindu family, and have not been able to prove that their forefather Teko Urao was in possession of the disputed land, recorded in the name of brother Bandhu Urao, and that Bandhu Urao was the Karta of the family. The plaintiff have also not been able to prove that his ancestral house was at Rampur, whereas the defendant has been able to prove that their forefather Bandhu Urao had a house at Rampur in which they are continuing their residence, which was solely owned by their forefather Bandhu Urao. The learned first appellate court ultimately held that the defendants had possessory title over the suit land and ultimately allowed the appeal. The learned counsel for the respondent has submitted that in view of the findings recorded by the learned first appellate court and in view of in absence of any finding in connection with previous partition, all the substantial questions of law do not arise, as framed, do not arise for consideration, and accordingly they need not be answered, and therefore this appeal be dismissed. Having gone through the impugned judgments, and the learned counsel for the appellant has not been able to substantiate as to how the substantial question of law as framed by this court by the order dated 17/6/2019 arise for consideration before this court. In view of the aforesaid facts and circumstances, this court is of the view that the substantial question of law as framed by the order dated 17/6/2009 do not arise for consideration, and accordingly they need not be answered. This appeal is hereby dismissed. He is a legal fellow.
Item 6, first appeal 136 of 2024.
Appellant.
Respondent 327 or should have just now served a copy, the reply of the IA notion.
Which IA?
IA number notion 10979.
What is 10979?
Yeah, that has not been filed. Just now it has been.
What is it? 10979 has also not been filed.
No, that has been filed, Rashid.
What is it? What is that IA for? 10979?
Additional evidence.
So you are seeking additional evidence, and they have opposed.
Yeah, they are opposing. It come on record, Rashid.
Where are they?
Just on his suspicious, he just not served it.
So
I think it was going on. Even the other respondents were also upset.
Some dead person is also there on record.
That was the main thing was that much. Now it has been they have been substituted. On the last particular lordship.
Dead person has been substituted, but whether the appellate court's judgment will still survive?
Yes.
On the last
Something
occasion,
which has to be
Lordship
seen.
had asked the question to the heirs of the dead person whether they want to reduce any evidence in the trial court or not.
Yes. Who are the heirs of the dead person?
They have appeared, Lordship.
Original plaintiff number 4.
Original.
They have agreed.
They have
Who
appeared.
are they? Who is representing them?
No, Lordship. Last time he was here, Lordship. Abhi bhi mila tha, just he was outside.
क्या बोल रहे हैं? Yes, what do you have to say?
The direction was given to us to take instruction from the party. The oral direction was given. Remand हो जाता है तो.
I just wanted to know what is your stand. So what is your stand?
अगर रिमांड हो जाता है केस को, तो आपने वकील साहब से कुछ देना होगा तो कौन करेगा? If it was a dispute.
He died at what stage
During the pendency of this.
of the suit? And you are the
We are the donors, Lordship. Plaintiff ही हैं, हम भी plaintiff थे, हम भी substitute कर.
co-plaintiff.
हाँ.
आप ही ने substitute.
हमारी ही गलती है. That I have already stated last time. He was not substituted because of the lack of the knowledge of the client's lordship. It was upon the advocate to do that. I think whether it was also informed to the advocate or not, that is also not clear. Because now many things will come.
इस केस में ये 3-4 टाइम लिटिगेशन होता है, उनके फोरफादर और जो दादाजी लोग वो सब लोग जो अपना यूएस दिए हैं, और अब ऐसा कुछ बचा नहीं कि चूंकि 3 बार घुस कर चुके हैं ट्रायल कोर्ट में, जो फाइंडिंग में आया है कि इनका ये प्रेजुडिस हाईली प्रेजुडिस हो रहे हैं, इसलिए ये वहाँ रिमांड हो रहे हैं, ये जो मेरा सजेशन है। और इस लाइक
If a person is dead, suit was decreed or dismissed?
It was
Dismissed. Appeal was filed by in the appeal also he was also the co-plaintiff.
No, plaintiffs को नहीं बनाया because I was knowing that at time of filing of the appeal, I inquired personally. He said, "No, this person is dead." Therefore, he was not made part.
और इनके तरफ से मुझे कोई क्या है ऑब्जेक्शन पिटीशन या फिर कोई फर्दर क्रॉस अपील भी फाइल नहीं किया है, आई हैव हाईली प्रेजुडिस देयरफॉर
They are not the persons who are aggrieved
यस
by the fact that there is a judgment against
यस
a dead person.
यस
They have not filed it.
They have not filed it.
Although
They
they
filed lordship and by the stamp reporting it came that such and such person has not been made part.
That is by
Then
the
after filing an application, we clarified that.
so
since-
they have no grievance regarding this.
that can be understood.
So therefore, under such circumstances,
The appeal can be heard on merit.
appeal can be heard.
Yeah,
They are not the persons who are aggrieved.
Yes, party here.
yes
They are party here.
sisters
Whatever, either way, lordship I am ready.
brothers are not avoiding. After death, my sisters are appearing contesting and brothers are not.
You see, in a case where a person
sisters
और आपका मेरिट में क्या सूट was for
Suit was lordship for a land, which lordship I am claiming title. उसका compensation हमको नहीं मिला, award was challenged. उसी point पे, in that point lordship is saying that several orders have been passed. It was decided against our forefathers. All the things are here. If lordship wants to hear merit, next week lordship.
जिससे एसयूडी डाटा बोल करके लाया करने ट्रायल कोर्ट हैज गिवन दैट कि यू आर नॉट इंटेंड एज प्लेड इन दिस बिकॉज़ अर्लियर
So अभी तो हम अगर मान लीजिए हम in case ultimately we find that there is no merit in this appeal, तो इनको तो बुलाकर करने का तो कोई मतलब ही नहीं।
ये तो आ ही गए पार्टी बनी।
तो आ ही गए, पार्टी बनी गए। They have not filed an independent appeal in spite of knowing that,
yes
and you cannot say that you did not know.
No, not because अपने
Lack of knowledge था बोल
Yes,
नहीं
yes.
सकते।
niceties
So
of law खाली हम क्या
you, all
सकते
of you were jointly claiming certain share in the property
हैं। Yes, yes, from the same family.
from the same family,
हाँ,
jointly.
same right title जो
Joint.
decide होगा। If whatever, if it is decided in my favor, it will be there in favor. Against me, it will be against me.
So there is no question of any prejudice.
Yes, against no other rights are being
asserted.
The appellate lordship and the performer defendants, performer respondents. That is there. इसमें हम कुछ जवाब नहीं कहेंगे. If lordship wants to hear this on merit, we will do it, lordship. It's a very small case. Next week we can do it.
First appeal number 136 of 2024. The learned counsel for the appellants, the other learned counsel for the parties are present. It is not in dispute that the plaintiffs are the appellant before this court. All the plaintiffs were full brothers. They were full brothers.
Yes. Cousin brothers, lordship. Shankar Mathur, right, lordship. He was son of Ramdar Mathur. Others are Anand Mathur, but from the common ancestry.
Who died? Shankar Mehta died.
Lordship.
Yes.
All the plaintiffs belong to the same family.
Same generation.
And it is not in dispute that plaintiff number 4 had expired at the stage of trial. But the co-plaintiffs did not take any steps to substitute plaintiff number 4. The plaintiffs were jointly pursuing their case in connection with apportionment. Apportionment का claim.
Lordship, the award was given to a different person, to the original.
In connection with claim of the awarded amount arising out of land acquisition proceedings. The award was prepared in the name of the defendants, and the plaintiffs were claiming the entire awarded amount.
In their own independent right identity.
In their
Own independent right identity.
independent मतलब सबका अलग अलग हाँ jointly.
Joint. आप plaintiffs हैं joint.
In their by claiming independent right title of interest with respect to the suit property, the title was claimed jointly by the plaintiffs. The learned counsel for the appellant has submitted that if this appeal is allowed, then the compensation amount would naturally be allocated also to the legal years and successors of plaintiff number 4. Correct? And therefore, no prejudice has been caused by not substituting the plaintiff number 4 before the learned trial court by other co-plaintiffs. He has submitted that the appeal can be decided on merits. The legal years of plaintiff number 4 are already appealed. आपको कोई परेशानी है? The learned counsel for the respondents have submitted that The respondents including the legal heirs of plaintiff number 4 who have been made party in the present proceedings by way of substitution has no objection if the case is otherwise heard on merits. Okay, ये तो हो गया कहानी खत्म. आगे
Those are second of the sum.
आपका एडिशनल एविडेंस आप इसमें दिए
हाँ
हैं.
इसी में साथ में
नहीं, एडिशनल एविडेंस का क्या किया है? क्या है
सर्टिफाइड कॉपी है, एक जजमेंट का पुराना जजमेंट का है.
आपका? क्या कहना है?
इसमें कहना है जब चूंकि ये प्लीडिंग में कभी भी नहीं आया, 2-3 सूट हुआ है इसके पहले भी, और ना ही अपने प्लेट में लेकर के आए, ना ही कहीं एविडेंस में लेके आए हैं, इसलिए जो ये एक्सेप्टेबल नहीं.
It is not even a part of the pleadings.
यहाँ part
कहीं आपने बोला है इसके बारे में?
तो सही नहीं है. ये मैंने जो देखा हुआ है उससे मैं जवाब भी दिए हैं.
उस दिन ही उसको करके डिसाइड कर देंगे.
IE number 109779 of 25 has been filed seeking to adduce additional evidence by bringing on record the decree, only the decree. Decree passed in title suit number 130 of 1947. The counsel for the contesting respondent
Yes.
has opposed the additional evidence by submitting that there is no foundational pleading in connection with the additional evidence which has been placed on the file. He has filed an objection to the same today during the court proceedings, which is taken on record.
Movie has already been given to them.
The learned counsel for the appellant has submitted that the matter be placed for final hearing and the additional evidence and the interlocutory application be heard along with the final appeals. Considering the submissions, the matter is adjourned and is directed to be posted for final disposal. Final disposal के लिए आ रहा है.
Yes.
8th of December.
एक रिप्लाई को भी लॉगिन फ्रेंड को नहीं देंगे.
अब दे दीजिए आपको इसको. चलिए.
Lordship, one of that one case with respect to the item number 17 of the today's date, where that this is an admitted matter. The notice was issued to all the respondents, and he said the notice has been served. Except respondent number 1, which an employee has received, so it may be ignored and it may be placed for the hearing. This case, execution proceeding has started.
This is second appeal.
First.
अभी तो आज तो नहीं हो पाएगा. आज हम लोग सेकेंड
इसको अलग दिया जाए हेयरिंग के इग्नोर करते हुए. Just is my prayer because the order in the last one not came at all. 70. Not for today, but just the appropriate format is appropriate heading, but it has come under the heading for orders.
नहीं, आपको respondent number 1 was not present. आपका respondent number 1 कहाँ का है? respondent number 1 नहीं, इसका employee से नहीं मानेंगे. You have to take fresh steps. FA number 100 of 24. A counsel for the appellant prays for and is granted 1 week time to take fresh steps for service of notice upon respondent number 1 through speed post as well as ordinary process, for which requisites be filed within a week. post on 5th of January 26. Office took back, speed posted.